Agree.
Item number 2, WA 2999 of 2023.
We are sorry, madam. You are responsible for, in fact, you put us in a situation that no relief can be granted to you. You were given opportunity to implead one of them as parties. You did not avail that opportunity. We wanted someone to be engaged as an amicus to take up your matter. You declined. Therefore, we have no other option but to dismiss the matter. Your appeal. We were helpless.
So may I speak something?
Just a minute. Let us deliver the judgment first. Considering the judicial pronouncements as noted above, in our opinion, the single judge has rightly declined to entertain the appellant's writ petition for non-joinder of necessary parties, despite opportunity having been given to her to implead some of the appointed persons, even in their representative capacity. Accordingly, we do not find any merit in this appeal, which is accordingly dismissed.
Sir, I'm a sports person. I was
agree.
competing with other sports person. I mean, out of 6 posts are vacant for the
Madam,
sports.
we are not here to convince you, but still we are telling you that there were 12 posts advertised. All the 12 posts were filled up. You were given an opportunity to please implead them as party. You declined. When you came here, we requested you, we gave you this option. We could have engaged some senior counsel to take up your case. You declined. What more can we do?
Sir, one post was reserved for
all right.
me, being a sports person.
All right, it's over.
This is, we have challenged the GIA order 2009. Validity of GIA order, grantinate order 2009. Now, I had given a memo on 7th, as I prayed Lordship to be taken up 21st. That is, memo is missing. Therefore, second memo I am giving Lordship to consider, as my learned friend wanted to be on 3rd week of April. That council for the state.
No, whether those matters are coming on 3rd week.
No, my lord. Actually, it's a batch of matters. So, if my lord will...
It has been fixed in those
No
matters.
date.
Obviously, we will see.
Let it come on 4th.
Batch matter. It's a batch matter.
Batch matter. Let's.
My lord will fix a date after 3rd week.
After?
3rd week of...
No, but I prayed for 4th. As my learned friend said, you mentioned it for 3rd week. I prayed for
He wants 3rd week of April. 3rd week of April. We will see. We will fix.
Because most of them are retired during pendency of this matter. Let it come, Lordship, 4th, so that 4th of this month, April, if they shout some time, that will be convenient.
Don't know guarantees. We'll see.
I will know one repeal matter. There is stage continuing. I want IA to vacate the state.
Yes. When was the stay granted? When was the stay granted?
I prefer to vacate the state.
Mr. Counsel, my lord wants to know when was this stay granted?
Granted before 6 months before.
All right. Let's go on.
Can I seek Lordship kind indulgence?
The second contempt notice has been issued, but no response. It's a matter of 1997.
Give. Contempt matter.
For second.
My lord, writ appeal fresh admission. A learned single judge passed the order to the passport authority to renew the prior to passport, my lord. It is clear violation of section 6(2)(f) of
Who are you?
my lord, Union of India. The contempt application that is posted to 2nd of April.
2nd April.
My lord.
So you want us to take up the matter on 1st?
No, 2nd. First is the holiday.
When did you file your appeal?
It is filed since 2023, December 2020.
23. But your appeal ought to have been listed automatically, right?
No.
So defects are removed.
Yes, my lord. All the defects.
Usher system.
Can I seek your kind indulgence?
So therefore,
Matter remanded by the Honorable Apex Court. The matter was relating to appointment of junior assistant. Now, before the learned state and
no, what do you want? Is there any observation made by
Yes,
the
Lord,
Supreme
the
Court that
document has to be disposed of.
so this order was passed in
2019,
2019?
Your Lordship.
Tomorrow for fixing a date of hearing.
This is the plate number.
Who is appearing for the other side?
The state is the petitioner, Your Lordship. We have carried the order of the state, this Honorable Court before the Honorable Apex Court.
Yes. Yes, see.
I'll read the number.
That should be heard. That is in 2019 order.
None.
We are in 2024.
I'll check up, my lord.
On second, Your Lordship, because tomorrow is holiday. It's a Good Friday.
all-
On the opening
It
day,
will come on third.
my Lordship, at the Lordship pleases.
Pardon to mention-
Second, I may not be available. May come, may not.
At the Lordship pleases. Much obliged.
Pardon to make a mention, my lords. My lords, this is a 482 matter. The matter was posted before the bench of Honorable Justice S.S. Mishra, my lords. But since he's concerned in the matter, I pray the matter was placed before the roster bench of Justice S.S. Mishra. But since he's concerned in the matter, he had directed the matter be placed before my lord so that a new assignment can be made.
You are not required to make a mention in such matters. These matters come to me regularly. So you don't mention. It will be listed before appropriate bench, or maybe order might have been passed also.
Pardon to make mention, my lord. Lord, it's a writ appeal up to notice matter. It's a stay having been granted. Hence, I'm a respondent. Hence, I agreed that I just want
To file an application seeking,
I just want to mention the matter.
have you filed any application for
Yes.
vacating the order of stay?
No.
Then make an application. File an application for vacating the order. Otherwise, you are satisfied with the order.
I am for respondent. State the appeal.
Please, we cannot draft your application. We cannot advise you also. We are just observing that if you have any grievance against the interim order, you can make an application for vacating the order of stay. All right. Then make a mention. We will expedite, surely.
Okay.
Is it a writ petition? Is it a writ petition?
Writ appeal.
Writ appeal.
And the order was passed in your presence
No.
at the time of issuance of notice.
Yes.
All right. File an application.
Pardon to mention, Your Lordship. Your Lordship, this is a second contempt matter wherein a direction was given for disbursal of the proceeds of my fixed deposit. Your
All right. So when was the order passed?
Your Lordship, the order was passed on 21/9/2020.
So your matter will not be listed. You give this slip to him. And inform, you just give this slip to him.
It's Union of India, my lords.
Union
of India. Give a slip. All right. And make a mention after 2 weeks. And tell the court whether the order has been complied with or not. All right. Before that, your matter, and please take care of that. So if I find that the order has been violated, I'll be very strict.
Your Lordship, they have actually filed a writ appeal against that order, which has also, Union of India has filed a writ appeal against that order, which has also not been taken up. So I was praying if both could be taken up together.
Then we will see. We'll see. Yes.
Trace admission item number 1.
In this case, my lord. Yes.
My lord.
You have the brief. You have the brief.
No, my lord.
You
Yeah,
are-
copies of
You are appearing for
one of the petitioner in the
respondent 5.
my lord. Copies of
You are for respondent 3 and 4.
My lord, copy not, sir. Let first copies of.
Cabinet petition has not been received by us, so we are not aware whether they have appeared. Now they are saying that we have appeared in the case, but really we have not received any cabinet petition.
Notice has not yet been issued.
Yes, my lord.
We knows the order passed by this court, 19/10/2023. You are for whom?
Respondent, my lord. 3 and 4.
Who is for the appellant?
You know, I am for the appellant.
What is the present position?
Your present position now by virtue of order of single judge. Now this opposite party number 4, respondent number 4 is now continuing as
That is interim.
that was the direction.
That is an interim arrangement,
That was the
status quo. Whether something has been done for the constitution of the governing body.
and, we have no idea about that. The government of GB has not been constituted as on date. And
Yes,
I will take instruction now.
Mirror,
1 week.
my respectful submission before Lordship is that formation of GB, whether the formation of GB was not the issue before the honorable.
May not be. May not be. If the governing body was required to be constituted.
We have no dispute over that.
If the governing body is constituted, the newly constituted governing body will take a final decision.
You know, that is one
So
part
let
of
the governing body, yes, the single judge was exercising writ jurisdiction. It's not ordinary suit, that particular relief was not sought, therefore, and that was not in the,
we are
after
not.
taking into account all the facts and circumstances, the order has been passed.
The question was
Let it come after 1 week. All right, in the meanwhile, let's put matter on 2 weeks, so as to enable learned counsel for the state to inform this court as to whether, in the light of this court's order dated 19/10/2023, passed by the learned single judge, governing body of the which college? Of which college?
that is the Ancholika Mahavidyalaya.
Anchorage Higher Secondary School, Talmud, district on board.
Has been constituted or not in accordance with the, what is the rule?
27.
No, 91.
Madam, may kindly say Odisha education rules.
Odisha education rules. Just all right, let it come.
Item number 2.
May I please your lordship? My lord, here applicant challenged the impugned order of the Honorable Single Judge at Annex 8, my lord, page 76.
Yes.
The operative part of the order of the Single Judge, my lord.
Yes.
At para 5 and 6, my lord, land additional government advocate on the other hand contended that even though petitioners have challenged the communication issued under Annex 6 on the ground that prior to publication of the final gradation list, Annex 6 has been issued, but there is no such pleading made in the writ petition. It is accordingly contended that in absence of such pleading, the contention raised by the Land Council for the petitioner is not entertainable. Accordingly, at para 6, having heard Land Council for the parties, after going through the materials placed, this court does not find any pleadings made in the writ petition with regard to allegation that prior publication of final gradation list OP number 3 has not issued. The communication under Annex 6, in view of such position, this court is not inclined to entertain the writ petition and dismiss the same. My lord, in my writ petition, at para 1, my lord, page 4 of the writ petition.
Where is Annex 6? Have you annexed that?
At Annex 6, my lord, at writ petition, Annex 6, page 106.
No, whether you have annexed that in the memo.
No, my lord, in writ application, I have not annexed. In the writ petition, it is 106. Page 4 of the writ petition, my lord, at para 1, categorically, may I read it, my lord?
Same school.
My lord,
Is this the same school which we were hearing in the previous case, first item? Name appears to be the same, Angul. And then, which was that school?
That is answering.
No, my lord, it's a different school. It's a
That is
different.
different.
That was college. Anchorage higher secondary college. Nowadays, college is much bigger.
So what was the dispute? I have not been able to understand.
my lord, Honorable Single
Seniority
Judge,
list was published when?
my lord,
When was the gradation list published?
my lord, no gradation, final gradation has not been published. A communication at page 106 of the writ petition,
Yes.
the OP3 forwarded the list to the Director Elementary Education OP2 for approval. But the no list has been published. As per the 15C of the Cadre Rule 97, the OP3 should have published the list and thereafter should be forwarded to the OP2 for approval. But no list has been published. Against that, I have filed a writ petition. But the Honorable Single Judge observed that I have not made any pleading that they have not published the list. But in para 1 of my writ application, it is categorically I have stated the last 3 4 lines. A letter number 2355 dated 2nd December 23 without publishing final gradation list after submission of objection of the provisional list circulated earlier.
That is Annexure 6.
My lord,
Is that Annexure 6?
Annexure 6.
No, it is dated 9/8/2023.
9.
All right, sorry. Writ petition, I'm seeing.
That is that.
Read petition, my lord.
Oh, sorry. Sorry. 400568. Your writ petition was 40568.
Yes, my lord. 40568 of 23.
Page 4.
Page 4, my pleading at para 1, my lord. Thereafter, para 2 also. Last 3 to.
Just a minute.
Page 4, last 4.
Yes, my lord.
From bottom, 4th line.
Yes, my lord. 5th line. Without publishing final gradation list, after submission of the objection to the provisional list circulated earlier by the letter dated 13/11/23, since cause of action arising in a common interest challenging the letter of the District Education Officer Khurda dated 2 December 23.
So what is this procedure?
And procedure is at
Where are the rules?
Rule 15(1)(c), my lord, cadre rule.
You know,
As page 26 of my writ application,
which rule?
my lord, rule 15(1)(c), as page 26 of my writ application.
So no objections were invited according to you.
Objection invited, my lord, in provisional gradation list, but in final gradation list, they have not published the list. Only they send a letter to the director enclosing the list without publication for approval. That is an impugned letter under Annexure 6 of my writ
What is the
petition.
meaning of this publication?
My lord, publication, it must be circulated to different BO office. This is the final gradation list.
This is publication.
Only the letter.
This was sent to the District Elementary Education, Director Elementary Education.
My lord,
He may be approving and publishing the result gradation list.
before thereafter final gradation list shall be published by 15th July of every year. Final gradation list to be published. এটা হচ্ছে the DO will publish the final gradation list.
Sir,
My
this is see the language. I am inviting so and so and level for promotion. Submit here with a final gradation list of so and so for promotion. You are therefore requested to approve the final gradation list. So after the gradation list is approved, it could be published, or it could be publication means making known to everyone the seniority list. What else?
Yes, my lord, this is the rule. They should publish the list, but they have not published the list. Many ineligible persons have been included. There's
Challenge the seniority list. Publication, the very fact that you know that there is a gradation list, it means that that has been published. You can challenge.
well, I have already. They have not published. We don't have any.
Completely, Mr. You could have challenged the gradation list. Rule 15 of Odisha Education Rules prescribes that the district inspector of schools of the concerned education districts shall maintain gradation list separately for the posts belonging to level 5, level 4, and level 3. Stop. Subrule C of clause C of subrule 1 of rule 15 prescribes further prescribes that the district inspector of schools shall invite objections by the 15th June before finalization of gradation list, and thereafter final gradation list shall be published by the 15th July of every year. Stop. The district education officer Khurda, through its communication dated 2/12/2023, addressed to the Director Elementary Education, informed about preparation of final gradation list and seeking his approval for promotion in accordance with the rules. Stop. The said later dated communication dated 2/12/2023 became subject matter of challenge before learned single judge in WPC number 40568 of 2023 filed by the appellant. Stop. Next. The sole ground taken by the appellant to assail the impugned communication was that it was prior to publication of final gradation list. Stop. Learned single judge, noticing the fact that there was no such pleading, that the said communication dated 2/12/2023 was issued prior to publication of final gradation list, dismissed the writ application, which is application by an order dated so and so, which is under challenge in the present intra-court appeal. Next. Learned counsel appearing on behalf of the appellant has attempted to convince this court that there was clear pleading in this regard in paragraph 1 of the writ petition itself. Stop. Next. We have carefully perused the statutory provision and the said communication dated 2/12/2023. Stop. It does not emerge from the said communication that the gradation list was not published. It is clear from the said communication that the gradation list was prepared and sent to the district elementary education, to the Director Elementary Education, Director Elementary Education Odisha for approval. So stop. For approval. So stop. Learned counsel for the appellant has also attempted to convince that there have been so many irregularities in the preparation of gradation list. Stop. On his own showing, it appears that the gradation list has been published, which is known to him. First off, if the petitioner, if the appellant has any grievance about his position in the gradation list, it was open for him to question the same on that ground. First off, next, we do not find any illegality in any legal infirmity requiring this court's interference with the impugned order passed by the learned single judge in the present intra-court appeal, which is accordingly dismissed.
Item number 3.
My lord,
The Odisha Elementary
Rule 15.
Rule 15 of Odisha Elementary Education bracketed method of recruitment and conditions of service of teachers and officers within brackets.
rules 97.
Rules, 1997.
Item 3.
Yes.
Sir, I filed the IA.
You have?
I filed the IA. Myself is the petitioner. I filed the IA 122 for amendment of my petition.
IA.
Sir,
IA
for
filing
amendment
number
of the original.
3719. 3719. What is the number of IA?
Sir, it is also deposited on 22nd. The second copy. My number is 3719/24.
3719 of 24. Flag C. Flag C.
3719/24.
Petition for amendment.
Sir.
What do you want?
Sir, I want to submit that fresh petition.
Huh?
The amendment petition. I will submit.
All right. What is the matter about?
My matter is for prayer for release of my late father's compensation amount under the RR policy of 2006.
Under?
2006 RR policy.
So why has it
Settlement
been
and
said?
rehabilitation.
Why for DB?
That policy.
A report of rights.
Which paragraph you want to amend? Which paragraph you want to amend? You have not stated anything in your amendment application?
Actually, actually I have to enclose some documents and the
So
policy
that is forming part of IA. How can we?
and some
presume?
changes also.
So where is the policy for payment of adequate compensation?
Sir, it is published in 2006 by the government.
Where is that?
Actually, I did not enclose that copy.
In fact, my friend wanted to enclose that document by way of amendment bills. Now he has paid for amendment, but in the schedule bill, he has not neither annexed that document nor he has paid what he wants the amendment.
The IA is incomplete.
Incomplete. That is the problem. He should give it as annex of 6 or 7, whatever it is. My friend can give it by way of amendment, so that.
Sir, actually, due to some typing mistake and some mistakes on it, it happened.
Then I'm saying.
Yes, but it's not included in document or he has not made specific government.
Yeah.
Which paragraph he wants to add? Or,
Sir, actually, I want to change in prayer also. Prayer.
so on your,
In prayer subject, I want to change some lines also.
so what?
Actually,
what the
So you
portion-
don't have any faith in the system of legal profession, in the legal profession.
Sir, actually, it's new to us.
Huh?
This land acquisition matter is new to us. Actually, we are not clear about this.
Are you a lawyer by profession?
Myself, sir, my lord. Myself is
If
the-
you are a lawyer, then why are you arguing your case? You don't have any friend in the profession.
My lawyer is
Never
Mr.
do it.
Ashok Parikh. My lawyer is Mr. Ashok Parikh. Actually, he is staying
Mr.
at
Counsel,
Rajasthan. Actually,
you are
due to old age,
perhaps you are not able to follow us.
actually, he is not able to come.
Our query, please understand what my lord wants to know. In your IA, you have not specified any amendment with regard to change in the original writ petition. Then you have not placed any document which you seek to rely upon during the course of hearing of writ petition. So this IA is itself is incomplete and defective. On your oral submissions, there can be no effective order passed, right? So you follow what my
This
lord.
is one aspect. The other aspect is that a lawyer should not conduct his own case. Never. Because you are so much attached with the cause.
Sir.
Engage someone. You must be having hundreds of friends in the profession. Ask someone to appear. Otherwise, you will be committing all such mistakes which you have committed. You can conduct someone else's case very good, very well. You cannot conduct your own case. As requested by the petitioner in person. The matter is adjourned to 2 weeks for him to engage counsel, an advocate, present his case. So never do this.
Item number 4.
It becomes very difficult. Why are we going to
Oh, Lordship, on behalf of my senior, Mr. Rautray, Lordship.
Item number 4 has been called.
Yes, item 4.
Yes.
On behalf of my senior, Mr. Rautray, Lordship,
Hmm.
praying for such adjournment, Lordship. Each on
When
accommodation
do you want?
next week, any day.
Next week, as
Yes.
requested on behalf of the petitioner. Does this matter on 2 weeks?
Item number 5.
Okay.
Item 5, may I please your lordships?
Yes, madam.
Your lordships in the last occasion, your lordship had directed my learned senior to obtain instructions regarding the compliance of this honorable court's order.
What has been complied with?
Lordship said directed to dispose of the representation. Here the opposite party against to allegation that he has encroached the government land and constructed a house. The Tahsildar has disposed of the representation and has issued B form for eviction and has fixed the date.
All right, the order has been complied with, madam. Order has been passed by the competent authority. Learned. We are disposing it off. Learned. Learned. Additional government advocate. Additional government advocate has informed this court that this court's order dated 23/3/2023 passed in WPC number 36988 of 2022 has been complied with by the Tahsildar Binka. in the Binka district, Subernpur, with passing of a recent order number 887 dated recent order wide memo number 888 issued wide memo number 888 dated 27/3/2024, a copy of which has been produced by him in the court. Full stop. After having seen this court's order, said order dated 23/3/2023, and the order of the Tahsildar passed pursuant to an order dated 27/3/2024, we are satisfied that this court's order, violation of which has been alleged in the present contempt application, stands complied with. Full stop. Considering the subsequent conduct of the contender in fully complying with this court's order by passing a reasoned order, in our opinion, disobedience cannot be said to be willful, requiring this court to proceed for contempt of court against him. Stop. The present contempt proceeding stands stopped accordingly. Stop. It will, however, be open. It goes without saying that the petitioner shall be at liberty to question the correctness of the order dated 27/3/2024 before appropriate petitioner or any other party, before appropriate forum in accordance with law.
Item number 6.
Grateful, Your Lordship.
So Mr. Das has some personal difficulties. I pray for next week.
As requested, 2 weeks.
Item number 7.
Item number 7, I am appearing for opposite party BDA minors. I pray 2 weeks time further minors. I
How
pray
much?
2 weeks time for the
Why?
minors to file counter minors. I have obtained instruction, parawise comment. I am in the process of preparing.
Your respond number?
Respondent number, opposite party number. Opposite party number to 3.
Opposite party, as requested on behalf of opposite party number 3. 2 weeks further time is allowed to file counter affidavits. Stop. List this matter on 2 weeks.
Item number 8.
May I please, Lordship? Lordship, petitioners are the inhabitants of the locality, and through this petition, they raise their grievance before your Lordship. In the interest of the public, the opposite party number 7, which illegally encroached the forest.
You were appearing before this court last time, no?
Yes, my lord.
This was the matter.
Yes, my lord.
What is the matter?
Your Lordship, on the earliest occasion, Lordship asked me which provision of the law has been violated by the encroachment of this opposite parties.
Yes. Yes.
Lordship, Orissa Forest Act 1972, Section 27, which tells about the offences.
All right, we'll just see.
May I read, Lordship?
Who is opposite party number 7?
7 is
Private opposite party.
Private. And this is Tarini Tipper and Truck Owners Association. What are they doing?
They're running a association for parking for the purposes of parking and
Parking of
trucks and tippers.
trucks.
Loading and unloading
In
trucks
the
and
forest
tippers.
land.
Yes, my lord. And this is the Annexure 4, which is clearly reveals that they encroach the forest land. Annexure 4, page number 34. This is the inspection report of the RI, and on the bottom second paragraph, which is clearly said it.
Revenue inspector.
Yes, my lord.
This is addressed to whom? Tahsildar.
Tahsildar.
So which date? Yes, let us see the provisions.
Lordship, section 27, subsection 3, subclause clause C.
Section 27.
Yes, my lord.
Subsection 2.
Subsection 3, my lord.
3.
3, subclause C. Subsection 3, clause C.
Clause C.
Yes, ma'am. May I read?
Subsection 3.
Yes, my lord.
218.
C.
You are on other structures,
They already.
other structures.
Yes, my lord. I am on the for the
They have put
person
up any
whoever.
shed.
Yes,
They
ma'am.
have put up any shed. They
Yes,
have
ma'am.
put up
Yes.
any shed, or they are keeping their vehicle
No, my
under
lord.
open.
They function. They are already structured in the office. Their office is running over, and this.
Now come to subsection 4.
Yes, my lord.
Read subsection 4.
When a person is convicted for an offense under clause A of subsection 1, the court shall order eviction of the offender from the land in relation to which the offense has been committed, and on such order being made.
So after he is convicted, the court will order for his removal. Till then he can continue.
Sorry, my lord.
Then what is the court? Court means which court?
Court means here is not explaining.
Is it High Court? Is it High Court? Can you interpret this that way under Forest Act?
So therefore, we had given you ample time to examine.
Lordship, there is written there is court.
No, if we read subsection 4 as it is,
yes, ma'am,
then it means that only after conviction the court will direct for removal of structures and. Yes, state.
Yes, my lord.
A serious matter.
Yes, my lord. We'll take instruction. Because there is a annexure which reveals that they have been directed to remove the structures.
3-time notice has already been issued to them.
Page 35. This is issued by forest range officer directing them to remove the structures or everything.
So that he may have an explanation that he had directed.
That is, they have annexed it.
Yes, yes.
So,
therefore, if the range officer, forest range officer issued the letter that in future, if any action is proposed to be taken against him, he may take his defense that yes, I had directed.
Let me.
So ask him to write letters.
Logical, and they won't go to logical.
So don't do anything. Write letters.
Now, what steps he has taken pursuant to this annexure 3? I have to take instruction and file in contract.
No, my lord seeks to know when you take some step,
Yes.
that has to culminate in some logical end.
Yes, yes.
That has to be brought on record. That is
Yes.
what
action has been taken pursuant to this letter, that I will file affidavit to that by the forester.
And if no action has been taken, action will have to be taken by you. All right. Don't wait for the court's order in such matters. And if the court has to pass any order noticing your deficiencies, then you may have to suffer also.
Yes.
Petition in the nature of public interest litigation under Article 226 of the Constitution of India has been filed by the petitioners seeking a direction to the Divisional Forest Officer Koenja to remove unauthorized occupation of forest land by opposite party number 7, bracketed name there, in Rebana Reserve Forest Area in Brahmanipal. Full stop. Our attention has been drawn by learned counsel for the petitioner to a communication dated 13/9/2023, bracketed annexure 4, whereby the revenue inspector Sagarpita has informed the Tahsildar of Harijandanpur about illegal occupation of reserved forest area by the aforesaid truck association stop. Next, learned counsel for the petitioner has also argued that though it is within the knowledge of the authorities that the said forest land, a reserve forest land, has been unauthorizedly occupied, no action has so far been taken for their removal. Full stop. Issue notice. Spot number 7. Issue notice. Mr. AGA accepts notice. So and so AGA accepts notice on behalf of
All 1 to 6.
of
1 to 6 opposite.
1 to 6. Full stop. Issue notice to respond number 7. List this matter on 8 weeks. Full stop. In the meanwhile, the concerned state respondents shall be under obligation to act in accordance with law in relation to the forest land in question. In relation to the grievance which has been raised by the petitioners in the present writ application.
Item number 9.
Oh, please, my lord.
As per the order dated 13/2/2024,
Item
the
9.
contempt of opposite party obtained time from this honorable court, within 6 weeks are complied the order of this honorable court.
Item 9.
Yes, ma'am.
Yes, I am waiting for this. What happened?
But no compliance affidavit has filed, and the Tahsildar not yet finalized the sealing proceeding. When was it is initiated in 1974.
Where is the order?
Order matter annexed matter. Annexed 1 matter.
Page 11.
Page 11.
Yes.
Lordship, paragraph 7, your lordships were pleased to direct to dispose of the sealing case by 30th of January 2024, my lord. And the lordship said on 13th February, directed to comply the order for compliance. I've talked to the Tahsildar, he says that notice has been issued, but all have not appeared because it's 74 matter. He has prayed for a week's time to get the notice of, may lordship may call it a week after only. 1 week after only, my lord. We have 74 matter, notice could not be served to all the opposite parties, lords. That is why he has prayed for a week's time. He has requested me to make a mention before lordships for only 1 week.
So, but he has already committed contempt.
And that is true, lord. Because
We are helpless.
No, sir.
We cannot do anything.
There is specific direction to complete.
We cannot do anything for the reason that you have not made any application for extension of time.
No, in the writ application, no extension has been paid, my lord.
No, you have not made any application for extension of time.
No.
And then the court's direction is that time frame has to be strictly observed.
Followed, my lord.
So you are not observing.
Right, my lord.
So we have the only option which you have left for us is to punish them for contempt. All right, let us proceed. Division bench. A coordinate bench of this court, while disposing of WPC number A18064 of 2023 by an order dated 11/9/2023. Disposed of WPC number by order dated so and so in following terms, paragraph 6 and 7. Next, it is not in dispute that that till date OLR sealing case number 47 of 1974 has not been disposed of. Full stop. It was clearly mentioned in the said order that the time frame had to be strictly observed. Full stop. There is no application filed on behalf of the contemners for extending the time within which the order was required to be complied with. Stop. In the court's opinion, in no circumstance the contemners could not have extended the time within which the order was required to be complied with. Stop. The contempt of court stood committed on failure on the part of the contemners to conclude, to dispose of the sealing case number 47 of 1974 on T1/2024, in the absence of any application seeking extension of time. Next, we are thus of the view that tentative view that appropriate action is required against the contemners for disobedience of clear order of this court dated 11/9/2023. Stop. Let. Who is the
only content of Tahsildar Kanika Miller?
Tahsildar maybe, what is his name?
Ashok Kumar Deuri.
Ashok Kumar Deuri.
Let Ashok Kumar Deuri file Ashoka's reply stating as to why the court should not hold him guilty of contempt of court and punish him accordingly. Stop. The such so-called reply must be filed within 2 weeks from today. Stop. 4 weeks. 4 weeks from today. Stop. It is indicated that the court shall pass appropriate orders in the present proceeding, depending also on the subsequent conduct of the contemptor. All right, that is enough indication.
Right. Item number 10.
Date में भी इसमें
Huh?
date में
8 weeks, 4 weeks, 4 weeks,
No, sir. This case now I'm filing in A.
6 weeks, 6 weeks. We are becoming a bit liberal.
Sir, I'm filing in IM wherein we have indicated to prayed therein to drop the content proceeding because we have already approached the Honorable Supreme Court, challenging the order of impugn.
Kindly see the last order. Kindly see the last order.
No, but they have challenged the order.
That has directed them to file a so-cause notice to the, at least the.
You could have done that.
My lord, kindly see the paragraph 5 of the last order. My lord, his director issued a notice and directed the contemptor to file a show cause. Paragraph 5, my lord.
You should have filed, you have not complied with paragraph 5 of the order.
Oh, of course, so cause in order, I filed an IM,
No,
that is
I
my
will not.
mistake. Lordship may call it on third, I will
1
file
week.
that so cause.
1 week, 1 week.
Yes.
Place this case on 1 week.
Item 11.
My lord, item 11 on behalf of Mr. Mohanty, my lord, may I place for the petitioner, my lord. Here, my lord, on the last occasion, my lord, kindly see the last order. All right, the counsel for the government has taken 6 weeks time for compliance of the order.
This is contempt number 546.
546, yes, my lord.
Order has not been complied with.
No, Lordship,
Last occasion,
were
time
pleased
is-
to direct me to obtain instruction regarding, because there was a direction to dispose of the representation, Lords, in the writ application. Lords, I had written a letter, he has not, Lords, responded to that. Lordship, which time, Lords, or Lordship may direct me, Lords.
Learned counsel for the learned AGA representing the contemners is unable to inform this court as to whether this court's order dated
Lords, dated 30th of August 2023.
2023 passed in WPC
25
bracketed PIL 25295/2023 has been complied with or not, for the reason that despite communication made to the contemner,
only one contemner.
contemner, he has not received any instructions.
No.
So stop. What is his name?
Lords, his name is Srikant Kumar Parija, Lords.
Let Srikant
Parija.
So Parija, Tahsildar, what is it?
Tahsildar, Lords, Marsagai.
Parsagai joined the court proceedings online on 1 week for this court to frame charge against him for deliberate disobedience of this court's order.
Item number 12.
And do you have any provision that if any charge is framed, his promotion shall be affected?
I think, Lords,
Please find out.
I will find out, Lords.
If we state that it will reflect in the CCR,
No.
I think.
Yes. Once we frame charge,
No.
then possibly you should not take up their matters for promotion.
Promotion, right, Lords.
So then we
deemed to a proceeding, Lords. So,
yes, the proceeding, and we are prima facie satisfied that he has committed contempt.
right, Lords.
Till disposal, you may consider.
Right.
Yes.
Lordship, the noting says additional affidavit has not been filed, but it is been filed on 20th March 2024.
Additional affidavit. Which item?
Item 12.
12. Yes. Whether order has been complied with?
No, Lordship.
No.
In fact, it is
In fact, no, the order which is not to be implemented, my friend has not filed. That's why by the order dated 22nd of February, also wanted the judgment should be made part of this court's record. So
have you
that,
filed?
Yes, it has been filed on 20th March 2024.
As is it there?
Not that.
And also a copy has been sought on government.
but
Learned counsel for the petitioner informs this court that a copy of which order?
A copy of the order dated
no, Mr. Lordship said directed him to file the judgment of Pavan Kumar Agrawal's case.
10th June 2021
Copy of the judgment dated 10/6/2021
and 25 August 2021.
and 25 August 2021.
In
Passed
common
in?
to in WPC number 2475 of 2020.
Both the orders were passed in one case.
In one case. These are
That is
the
a
two
batch
subsequent
matter.
dates.
Batch matter.
Batch matter. Lordship.
2475 of 2020 and batch.
Yes, Lordship.
That is Pawan Kumar Agarwal versus Additional District Magistrate, Competent Authority and Land Acquisition and others.
Correct.
Have been filed. So they said documents are not there on record. So list this matter on 4 weeks. The
Lordship, I have two sets of extra copies. If it is being taken now, that also can be done.
you will have to file online, you don't do. In fact, I want, as Chief Justice, I would like to have your response. If we go for 100% online filing, then will you have any problem?
No problem, maybe problem for the officer advisor, there is no problem, but so far as young lawyers are concerned.
Young lawyers, we are there to help
more
them.
computable.
We have facilitation center.
We will help them.
Yeah.
And if
Because it's more filing through e-filing, it is a bit costly for them because they charge 30 to 40 rupees per page.
who
For
cha-
the persons those whom they approve, because they
we
don't.
will provide you free of cost.
That is that provided that suggestion may be given to the bar.
We can do that. So if you, yes, any lawyer who has any problem in filing, we are there. So they will have not to suffer in any case. Just a process. So we are there to help them.
I can only suggest.
But what is the problem?
The elections around the court.
All right, it's just an observation. In no case the Chief Justice is going to force anything upon you, trust anything upon you. So just if all of you agree, then we can start. If you have any problem, today or tomorrow, you will have to adopt that. You don't have any other choice. And then you have achieved, particularly Odisha High Court has achieved so many milestones. So why this? In Patna, we have done that. It's 100% filing online. It is not very difficult. And there, that facility is not there, which I am suggesting. That you will have the facility of free of cost. Manpower will be there, filing process. The difficulty which all of you and the system is facing is in the absence of any method for payment of court fee. That we shall evolve. That we shall be doing something. Your association is also losing revenue.
Right.
Some urgent matter, if you also file online, it cannot wait for urgent listing. So you have to immediate registration is required. For that reason also.
We'll see.
Once you clear the defect, I think the next moment it is listed.
So
Mr. Counsel, if the bar should be clear about it, or not bar, the citizen, the residents of Odisha should be confident about it, that because of any procedural defect, they will not be stopped from approaching the court. Be that if your application is defective, but the matter is urgent. We will hear that immediately, 1 hour after filing of, or without your filing of application.
Diary numbers are not getting listed. That is what.
These observations are subject to modifications in the SOP, in the rules also. In the High Court rules, we may require modification. So it's just an observation.
Come up with
My lord, a standing order whereby your lordship have detailed out certain procedures to be followed for getting the matter diarized with a diary number, and thereafter, after removal of the defects and SR, it will be again converted into another number. And in the process, my lord, once a case goes to that defective list, within 30 days, as per the standing order issued by the High Court, we have to clear that defect within a period of 30 days. During that period, as your Lordship was just the revealing, it fell from your Lordship's mouth. Once a defective order matter that cannot be listed with your Lord, even if whatever urgency it may be having.
No.
That is what the standing order puts.
There are two things. You must be knowing about one development, that now that period has been extended from the date of reporting, not from the date of filing.
Well,
earlier it was from the date of filing. No? Now it is from the date when the defects are 30 days from that. The period starts from that one. And the other thing is, let us make an attempt. Let us fail, but make an attempt. All right. With this, I will. Yes, you can suggest.
One more thing, if your Lordship kindly
Mr.
consider.
Mahanti, what my lord says, through bar association or whatever suggestion, you sort out. And
we'll go
you
to the
can-
bar.
It's not just a suggestion.
Yes, no.
Just a suggestion. Let us, and I am saying this also for the reason that when Patna could do it,
one copy,
No, 2 copies.
2 copies,
2
for
copies.
division benches.
We have now mostly, at one point, because of the intervention of the Honorable Chief Justice, some of these commercial matters or big tender matters, we filed in online mode. But now gradually we have shifted back to this physical mode. The reason I must share that with your Lordship is the reason is that the clerks are also there.
clerks will have to be trained.
Yes. So that's also a big issue which...
Clerks will have to be trained. Clerks, we shall provide training to them also.
Bar can take a call to conduct some workshop for legal assistance.
And leave that to us. You tell us that the clerks are required to be trained. We shall provide them training facility. You don't take burden on yourself.
That is something, that's an area which
Yes,
we
yes.
improve on.
The lawyers, the law clerks, these classes shall be trained. We shall do that. All right. So how many batch wise we can train clerks? And then clerks can train other clerks.
Lordship, a short date may be fixed. A short date may be fixed, 2 weeks.
2 weeks. So 4 weeks, there's some reason why we are fixing.
In fact, the petitioner is suffering for last 4 years, Lordship. For last 4 years, his residential
Suffer 4 weeks more. There is some reason. We expect that in the meanwhile, they shall comply with the order. All right.
Yes, Lordship. That.
Yes.
Item number 13.
Listen, item number 13. I filed a further so-called affidavit on 22nd. There I have stated, in the meantime, we have paid him 16 lakhs and all. And all the promotions and other things have already been given to him. Because he worked in 3 to 4 or different colleges, the authority concerned had asked the principal to give the particulars so that the balance amount can be paid to him. And that is why we have prayed for some more time. That is the so-called affidavit dated 22nd March.
3 weeks time they have prayed para 10.
When did you file?
I filed on 22nd of this month only. Affidavit dated 20th of March.
Arvind Agarwal.
Yes,
Para 10.
7 and 8 we have described. And para 10 we have prayed for 3 weeks time to fully comply with Lordship's order.
Taking into account the admitted fact that there has been substantial compliance of this court's order dated 3/4/2023, passed in WPC number 328976 of 2017.
My lord, sir, that WPC number is 8976.
WPC number
8976 of 2007.
Oh. Order dated?
3/4, that is correct. 3/4/2023 in WPC number 8976 of 2017.
Page 10.
Yes.
8976 of 2017. The request, the prayer made by the opposite party in the so-called affidavit filed on 22/3/2024 for grant of further time to comply with remaining part of the order, the matter is adjourned to 4 weeks. Stop. In the meanwhile, the contender shall be under obligation to fully comply with the court's order. All right?
You'll also fix it.
4 weeks.
Item number 14.
Item 14, your lordship has been pleased to, actually the petition was appearing in person. My lordship.
14.
Item 14, my lord. And my lord has been pleased to, my lordship has been pleased to appoint my learned friend as Amicus Curiae in this matter. Lordship, I have already taken instruction. What he is praying for in this case is contempt that 8/11/2023 order. My lords, kindly see, the order has already been passed by the Central Administrative Tribunal, and that is 22/11/2023. I'm serving a copy. I'm afraid.
Is similar, the petitioner father is a psycho patient, my lord. I prefer, my lord, some 2-3 days, some documents, my lord. I will verify, my lord, to assist your lordship.
By Mr. So-and-so, Lord Amicus Curiae. This matter on 1 week?
Yes, your lordship,
1
please.
week. In the meanwhile, just
10 days if you like, lordship.
see, in such matters where the petitioner is appearing in person,
My lord.
he has to be convinced by you also and
Pardon,
him
lordship.
also that this is the situation, this has been done, and nothing more can be done.
In fact, my lord, department also should assist this person. I can.
That should be the approach.
My lord. But this pleadings is half pleading there.
He will be improving.
Yes,
My lord.
I submit it.
Obliged.
Item 15.
So order has been completed with payment has been made. I will give a details of the payment to my friend.
Payments have been made. We're dropping it. It appears based on submissions advanced at the bar that this court's order has been fully complied with during the pendency of the present contempt application. So stop. The contempt proceeding is accordingly dropped, but with an observation that it shall be open for the petitioner to raise his grievance if before appropriate authority, if any entitlement. This was regarding pension.
No, my lord, it is for the work done by the
Tender or some refund was due to.
tender.
Dropped controversy. All right.
Item number 16.
May please, your lordship.
But sir, I filed the so-called affidavit.
Not received copy, my lord. Copy was not submitted.
I filed on 22nd of March.
Yes.
Noting also not filed.
So whether the order has been complied with or
Yes, yes, Lord. Order is complied with the amount due to be paid to the late Tarini, the present petitioner father said notice has been issued to them to receive the amount by giving the bank details and other documents. We have given it.
Is your lordship please, but they file to provide a
give a
copy of the omelette so
I'll give a copy.
provided, we'll provide him a copy.
Yes, Lord. Just now I will give you a copy.
Learned counsel, learned AGA has informed this court that this court's order has been complied with in as much as a decision has been taken for payment of
But the outstanding dues of the
outstanding dues in respect of late
other mills, I think
is the petition of the legal heirs of his father who is a contractor.
father of the in as much as
petition number 1
decision has been taken to pay the dues which was admissible to father of the
petition number 1 mills.
petitioner number 1 to his legal heirs, and a communication has been made in this regard to
all the petitioners mills in this case
the petitioners
on 20th of this month mills.
On 23/2024 for providing the details of their bank accounts.
Yes, so PAN card, bank details and
details for the purpose of making payments. Stop. Next. In such view of the matter, we are not inclined to proceed further in the present proceeding, which is accordingly dropped.
Item 17.
17, I filed this affidavit on 21st March.
Yes.
So-called affidavit wherein I have stated that matter we have approached the Honorable Supreme Court in SLP, which is pending.
But no stay is, my lord. There is no stay, my lord. It is on a defective list as per the case.
When did you file?
No, sir. I filed on SLP diary number 11,305, dated 9th March.
9th March. And when was the order passed?
This order was passed on
September.
yes, my lord.
6 months thereafter.
15/9/2023, my lord.
And what was the order?
The order was, also can you look at?
The case law which we have referred to,
Yes, my lord, so
that has already been confirmed by.
Yeah. BKD infrastructure disposed by judgment dated, therefore government to take a decision in line with the judgment passed in BKD infrastructure, my lord.
This BKD has been.
So when was the order? When was the order passed? Order of this court?
This court's order is dated 15th of September 2023.
And by what time that was to be implemented?
I mean, so time granted was no, so
Not good.
there is no time given, my lord.
No,
Then,
no time was granted.
then what kind of, then where is the contempt?
But in BKD there was time.
BKD case, my lord, they have.
What was the time?
No, they have, there is a demand, they have quashed and, my lord, demand was quashed
Sir,
and directed. The time stipulated is not there.
We have asked the question. This court said that in terms of BKD
Your lordship.
infrastructure,
Yes.
that BKD infrastructure whether has some time stipulation.
No, your lordship, there is no time.
There was
No.
Oh, let us see what was the order. What was the order?
It is agreed by learned counsel for the parties that the issue involved in this case is analogous to one involved in BKD infrastructure. Therefore, in view of detailed reasons stated in the judgment in BKD, this restriction stands disposed of in terms of the said judgment. That is what I am asking.
What was the direction in BKD?
BKD, your lordship said there is a retrospective of a circular. They have implemented retrospectively. Your lordship quashed that circular. The BKD case is that they are demanded basing on the that circular, retrospective operation of a circular. And here is a case of that basing on the petition is entitled to refund some amount. For which they denied on the basis of this circular. And the BKD judgment, this honorable court pleased to hold, it cannot be retrospective operation, my lord. And the BKD, in the case of BKD, government filed a SLP.
Your amount is to be refunded.
Your amount is to be refunded. My amount to be refunded.
So in BKD, whether there was any time frame given?
No, your lordship.
Within for refund?
No, my lord, there is no time frame is given.
Then how do you say that the order has been violated?
Your lordship, this time was not stipulated, but there is a, your lordship, can you see the contempt, my lord?
No, our question is different. Our question is that one can be punished only if it is seen that he has violated something. So he has violated what?
Your lordship, the time, this order is two-part, my lord. Even though it is time stipulated was not given, but there is a order, my lord.
There is an order, so they'll comply with the order.
They are only saying because of SLP we are not complying. The so cause if your lordship.
That is different. So the SLP, the question is that we must have something to proceed against them. Where is the violation? Have they denied? Have they said that though there is an order, we will not implement?
These same
willful violation.
They say only because of this SLP, my lord, we are not complied. Was a so cause.
Where is the willful? You have to satisfy willful. Willful disobedience. Simple disobedience will not come within the fold of.
Your lordship, then you have to go to the page 10 of the order, my lord. Lord, I am permitted to place the lordship. The petitioner has filed the writ application seeking quash the office memorandum dated 17th June 2021 under Annexure 14, modifying the office memorandum dated 19/11/2019 under Annexure 13, which was effective from the date of to be retrospective effect from 7 July 2022 to 18/11/2019, as well as the letter dated 15/6/2021 issued by the opposite party number 4 executive engineer Baliguda R&B Division Kandhamar, directing the petitioner to execute supplementary agreement basing on the office memorandum dated 7/6/2021 and further to issue a direction to the opposite party number 1 to release the amount. Your lordship,
you are reading prayer portion.
No, my lord, this is the order.
Order, all right. Then
order. This is
prayer portion. To release what?
to release the amount as per the recommendation of opposite party number 2 by letter dated 15 January 2019 under Annexure 8. It is agreed by the learned counsel for the parties that the issue involved in this case is analogous to one involved, that is WPC number 3019 of 2021, BKD Infrastructure Private Limited, superclass contractor.
That we have read.
Yes, also.
But the question is which part of the order read with BKD order has been disobeyed?
The timeline specifically has not neither it, my lord, in this.
There is no contempt.
But I'll satisfy.
1 year after the order is passed.
Lord, even if this, my lord, I'll satisfy for lordship that even if timeline is not given, and there is a direction, the contempt lie, my lord. I'll satisfy.
That is difficult. If there is no timeline, then the court at the maximum say 1 year. Not before 1 year.
No, expiry 1 year, then I will be, my lord, the limitations, my lord.
No, the contempt limitation will not apply. The contempt will begin from that day.
Look, I will, my lord, I will prepare more, my lord, I will submit. My lord,
no, nothing.
No, my lord, they have a lordship.
If you want, we can dismiss it, right?
No, my lord, I will give some, my lord, I have not, my lord, gone through this about the subject. The query of this honorable court, I will satisfy.
Sorry, as you wish.
Your lordship, kindly section 2, my lord, I have a contempt act, your lordship kindly have seen. Section 2B, my lord.
Read it. Please read it.
Lord, civil contempt means willful disobedience to any judgment, my lord, decree, direction, order, writ, or other process of a court, or will breach upon any undertaking given to a court, my lord. Lord, I humble submit, it is a order, my lord.
It's an order. They will comply with. Are they saying no to it?
But they have not complied.
They will comply. They will comply after 1 year. After 1 year, you may come. That despite the order, even after lapse of 1 year, they have not complied with. Therefore, they have no intentions to comply with. Then your grievance can be entertained.
This is a section 2B, there is a order, Miller. This contempt act section 2B, there is a order, but the time, even though time stipulated was not.
Therefore, you will have to wait at least for a year. And that is the Supreme Court's decision also. Please examine that when there is no timeline, there should be some, the order should be complied with within some reasonable period, and that is 1 year.
But I will
based on the allegations made in the contempt petition and contempt petition read with this court's order dated 15/9/2023. Passed in WPC number 28427 of 2021, and this court's decision in case of BKD Infrastructure Private Limited, superclass contractor so and so, dated 8/9/2023. WPC number 30191 of 2023. We are of the view that no case of deliberate disobedience of this court's order is made out in the absence of any time frame prescribed by this court for refund of the amount.
Release of amount.
For the release of which amount?
The differential cost, recovery differential cost. The
release of the amount of differential cost. Full stop. This contempt petition is accordingly disposed of with an observation that the petitioner shall be at liberty to approach this court with a contempt petition. By filing a contempt petition after expiry of 1 year from the date of order, comma, if in the meanwhile this court's order for release of the said amount is not complied with. That will do?
Yes, sir. Oblige.
Yes, so the contempt will start from that after 1 year.
1 year after date of passing of this order.
Yes.
Item number 18.
So item number 18 and 19, I filed the compliance affidavit and we have complied the lordship's order by passing a resumed order.
So, AGA has informed this court that this court's order has been complied with. Court's order dated so and so has been complied with, in as much as a reasoned order has been passed by
So on 24th of March.
By whom?
By the contempt OP number 1, superintending engineer.
OP number 1. Stop. Learned counsel for the petitioner does not dispute this position. Stop. The contempt proceeding stands stopped accordingly. Yes, go.
Item 19.
May I please, Your Lordship? Your Lordship, this contempt is against the non-compliance of the order dated 8/1/2024 of this Honorable Court.
19.
19, Your Lordship.
18 में दो है वो. 18. Yes.
Wherein, Your Lordship, the prayer of the petitioner was that after the closure of the loan amount, the petitioner was seeking for the documents relating to the mortgage property.
Where is the order?
Order is Annexure 1, Your Lordship, starting from page 9, Your Lordship.
Page 11 is the order.
Page 11 is the order, Your Lordship. Your Lordship, 4 weeks' time was granted to the contender to take a decision on the application of the petitioner, Your Lordship.
So who is for the bank? Bank was a party.
Yes, Your Lordship.
Someone is appearing. Which
I-
bank? Mr.
Without issuing notice to the bank, it was disposed of.
Yes, Your Lordship. At the stage of admission, it was disposed of.
At the time of order being passed, there were none for the bank.
No, Your Lordship. After that, the certified copy was served on the contenders, Your Lordship.
All right. Issue notice. Issue notice. Is there any counsel for the bank here in the High Court?
Union Bank of India.
They have a panel of lawyers.
There are someone. Next week.
Oh, pleasure.
1 week. Does this matter on 1 week? So in the meanwhile, learned counsel for the petitioner shall be at liberty to serve the requisite number of copies of the present application on one of the learned counsel who represent Union Bank of India. Union Bank of India.
Othabira branch.
Union Bank of India in this court.
Pleasure.
Item number 20.
So item number 20.
May I please, Your Lordship?
The order has been complied since 31st of March, 31/10/2023.
That's order has not been complied here.
Item number
20 Millers.
20.
Let's see if they have intimated just yesterday, Miller. Yesterday at 6:22 p.m. Millers.
They have done something.
So, Lordship, they have not.
You should be happy about it.
No, Millers. Lordship, may
No.
kindly for a moment.
Let us
This
see
is
the order.
Yes, Lordship, the order passed by this honorable court is Miller page 15 Millers.
Yes.
Page 15. Relevant is Miller the page 16 Miller, paragraph 6. May I permitted to place Miller. As agreed.
Whether the representation has been
Yes.
disposed of or not.
Yes. No, the representation has not been disposed of. This is the second round of contempt application. Miller.
Please, Mr. Counsel, whether the representation has been disposed of or not.
No, till now, yesterday they have intimated, they have disposed of, my lord. The fast route contempt application also.
They have intimated that they have disposed of your
Disposed of my
representation
application yesterday.
yesterday. Over.
Yes, my lord. Let
matter-
me kindly appreciate, my lord.
What appreciate?
Two academic
There is
session we have lost.
absolutely no contempt is made out on the basis of what is there.
Okay,
Sorry.
academic session, my lord. we
If
have
you have any grievance
Sorry.
against that disposal and that order,
my lord.
against the disposal of representation, then you have other forms available.
Praise God, thanks.
By an order dated 7/7/2023, passed in WPC number 17508 of 2023, comma, without expressing any opinion on the merits of the case, the opposite party number two here also.
Let's opposite party.
Here only one.
Here is a one, my lord.
Here only one.
Here is only one.
Opposite party number one, bracketed opposite party number two in writ petition, bracket close, to consider a representation filed by the petitioner and pass appropriate orders in accordance with law within 3 months. So, learned AGA, next paragraph, learned AGA has informed this court that the petitioner's representation has been disposed of and a communication in this regard has been sent to the petitioner yesterday itself.
No, I say it has been done or given on 30th itself.
No, not, sir. This
But
is
he
the-
claims that it has been given.
Yes, this is the mail communication.
Just
Yes,
on 30/2023.
31/10/2023.
31/10/2023. So, learned counsel for the petitioner, however, disputes this position and states that he received the order yesterday evening.
Yes.
So, next, be that as it may, comma, since a petitioner's representation has been disposed of by this court's order in compliance of this court's order. There you go. So, has been disposed of in compliance with this court's order. We are not inclined to proceed further in the present matter. This contempt application stands, the contempt proceeding stands stopped. Yes.
21, sir. That's a liberty to express cause.
It goes without saying that the petitioners had been at liberty to question the correctness of the order passed on the petitioner's representation.
Great. 21.
May I please, your lordship? Yes. Permitted to place, your lordship. There is a direction to dispose of the annexure 11, my lord, by the Bhubaneswar Municipal Corporation. You have not yet, my lord, disposed.
Who is?
It's Corporation, Municipal Corporation, Bhubaneswar, my lords.
Who appears?
They have a panel, if you also can, you can solve a copy on any of the panel councils.
Solve a copy.
Can take notice.
3, 4, my lord, any, my lord, I can sub.
Mr. Pranay Mahanti or Mr. Vibhu Tripathi.
If 10 persons, my lords, and he can solve
Any
any
one of them who usually appear for the Bhubaneswar Municipal.
Mr. Devakanta Manthi has also received copies from your lawsuits.
Therefore, Mr. V.P. Tripathi is not to be appearing.
You have instructions to appear in this on behalf of Bhubaneswar Municipal Corporation.
What is your name?
Narendra.
But you are not on the panel.
No.
Mr. V.P. Tripathi.
Serve on him. Anyone on him.
I'll serve.
This contempt application has been filed without serving a copy thereof on any learned counsel for the Bhubaneswar Municipal Corporation. So, the court has been informed that there is no arrangement made by the Bhubaneswar Municipal Corporation. Why Bhubaneswar Municipal Corporation for receiving of the notices in the High Court? Notices of cases which are instituted in the High Court. So, in such view of the matter, we such view of the though there is a panel of counsel for the for the Bhubaneswar Municipal Corporation. So, let 2 copies of the contempt petition be served on either of the panel counsel of Bhubaneswar Municipal Corporation by the petitioner, by learned counsel for the petitioner by Monday, for the purpose of seeking instructions as to whether this court's order dated 27/1/2022, passed in WPC number 29711 of 2021 has been complied with or not. Next slide. We consider it necessary to observe in the present order that substantial number of cases are instituted in the High Court in which Bhubaneswar Municipal Corporation is a party. So, for expeditious disposal of cases, it is imperative that the notices are served upon the corporation without any hassles. Stop. The Bhubaneswar Municipal Corporation, in that background, should consider making such arrangement where under the notices can be served upon one of the counsel of the cases which are filed in the High Court in which the corporation is a party.
I think the Lordship had earlier made such an observation in another case of municipal corporation laws. I think 1 month or 15 days back, this observation was made by.
Repeating.
I will also intimate them so that.
Yes. So let them be soft to the institution may be soft to them.
Right.
Otherwise. Yes.
Item number 22.
My lord, I for condonation of delay of 3 days. Order
Why have you not buttoned your shirt? Shirt, upper thing, this thing.
Sir, I was the teacher.
All right.
Second time I am appearing.
So you should
Retirement time appearing.
You should be teaching us. Why are you?
College teacher. Retired.
Yes.
For my missus, I elected.
For?
For my missus, she expired this June. She was a handicapped person.
So the petitioner is your wife. Please leave the courtroom. Let him argue.
I think I can.
Please, if you can argue, then you argue.
Yes, sir.
Why should you argue your wife's case?
Sir,
Mr. Mishra will argue your.
A handicapped person. I have seen this.
Why you are not required to repeat it? This is Mr. Counsel. This is contempt of court.
All right.
You are saying she is your wife, and you are a lawyer.
All right, sir. All right, I'm sitting.
You should go back and properly dress up, properly robe.
IA filed for condemnation of delay. 3 days delay, my lord. The order is 14/10/22. Impugned order of honorable single.
WA 1525.
My lord, 1525.
Yes, what is your grievance?
Order, my lord, dated 14/10/22, and writ appeal was filed on 16/11/22. Certified copy obtained on 19/10, my lord. Only 3 days.
AE number so and so. Delay of 3 days control.
Sir, pointed to 2 days. Well, yes, sir.
2 days. 2 days control.
Our registry has pointed out 2 days delay. They're gone.
Your lordship, hear the case on merit.
Just let us see whether. Where is the order? Where is the order of the London single judge?
The order is, my lord, at page 175. 175.
The long order.
My lord.
All right, Mr. for admission.
Fresh admission. This was issued both admission and
As a fresh admission, it will come
delay
in.
petition.
Delay has been condemned today. It will come in fresh admission. Whether it is to be admitted or not, we'll see.
Yes.
23. In item 23, my lord, I said 2 weeks time for filing a substitution petition. In the meantime, the respondent has expired. I'll file a substitution. Will also grant me 2 more.
It is stated by London AGA that during the pendency of these appeals, the respondent number 1.
Yes, ma'am.
Respondent number 1. Expired. First off, he intends to file a substitution application. First off, for that purpose, when did he die?
That I don't know, but there is a noting that notice return
Addressee
expired.
Addressee expired.
Yes, ma'am. That I am collecting that data when
4 weeks time is allowed for the said purpose.
And another noting is also there. Application for substitution upon the death of respondent number 2.
Also, in
Not
the meantime, two respondents
filed.
have died. My lord, file plus may give me 4 weeks so that I can file substitution in respect of respondent.
Respondents died during the pendency of this appeal. The London AGA intends to file a substitution petition. And
Perhaps that respondent number 2 is a comment.
noting is
That is
wrong.
wrong. That noting is a wrong.
Because settlement officer.
Yes, ma'am. That is a government.
settlement officer cannot die.
Yes, ma'am. That noting.
No, secretary. Respondent number 2 is secretary, Department of Finance.
Nothing is wrong. So I will file respondent number 1.
So can you send the file?
Sorry, my lord, because of that noting.
All right. So you'll have to file an
noting. Office noting is wrong. Why? Send it.
Wrongly.
Wrongly. We pointed it out.
4 weeks. Yes.
Item number 24.
My lord, I am filing an additional affidavit.
Superintendent of notice content.
My lord, in this case, I am filing an additional affidavit today. I have served a copy. May I pray, my lord, the same may be kept on record. Well, I have filed already.
But today, you filed today.
Yes, I am filing the application today. It is there. I have handed over.
Stated by London Counsel for the appellant that an additional affidavit has been filed today itself.
File in the registry. E-filing.
File in the registry. No, not here. File in the registry.
As your lords.
Is
I'll file it the registry. I have
going
solved
to be filed today. So stop. List this case on 1 week with this additional affidavit from the court.
Item number 25. Item number 25, may I pray your lordship may take up this matter on Tuesday?
Tuesday, why, sir?
I am not feeling well today.
All right.
So I have to,
All
that's why I'm.
All right. As requested on behalf of the appellant state of Orissa, list this matter on 2 weeks. It's a long matter.
There are batch of matters. Very short point is involved, so it will take only half an hour.
Half an hour.
Item 26.
Pension, related
No,
to
no,
pension.
not regularization.
Regularization and pension also.
Not pension, only regularization. Item number 26.
26, I would say, for a 10 days delay. Having of it.
So we'll have to issue notice.
Well,
We may have to issue notice, and if you don't have any, if there is no merit in the case, then we can condone the delay.
merit. The minus balance matter, accountant general filed the appeal. Here, only grievance is that only grievance is that, so let's see, may turn to.
So what is wrong with the order?
Wrong is that they're directed to pay the amount by the accountant general to the respondent. The state government has to pay. Let's see, turn to page 20 of the operative part of the order passed by the single judge. May I please?
Which paragraph?
Paragraph 8.
8.
May I please?
What is TW? TW.
A paragraph it having had on council parties and after going through the material available on record, it is not disputed by the either parties that an amount of 30,000 has been wrongly credited to the GPF account of the petitioner for the.
You are reading which paragraph?
Paragraph 8 of page 20. Page 20. Page 20.
Yes.
The parties and after going through the material available on record, it is not disputed by either party that an amount of 30,000 has been wrongly credited to the GPF account of the petitioner for the year 96-97. It is also not disputed by either party that the said fact was only brought to the notice of the petitioner after his retirement on 30/11/2014. Since it is found that the petitioner has no fault with regard to 30,000 in the opening balance for the year 96-97, and since it is also found that no such notice was ever issued to the petitioner in terms of the provision contained in Rule 36(2) of GPF Odisha rule, it is viewed that the court that the petitioner is not liable to refund the amount so far as the interest part is concerned, amounting of rupees 1,26,723. This court therefore permits the authority, opposite part note 3, recover a sum of rupees 30,000 which was wrongly credited to the account of the petitioner for the year 96-97 and release the balance amount of 43,727. This court was held recovery of rupees 82,996 from the leave salary of the petitioner by the opposite party note 2, basing on annexure 1. By annexure under annexure.
So you were which opposite party?
Here I am opposite party number 43, directed to refund the 43,700.
You were opposite party number?
Here opposite party number in the writ petition, the opposite party number 3.
3. And what was the direction? Your opposite number 3 means Accountant General.
My lord, accountant. Actually, your lordship may kindly come to page 23. Your lordship may kindly page 23.
It is when the court directs you to return, it does not mean that you return from your own pocket. You have to issue authority slip.
Authority slip is that the GPF account has been closed. There is nothing left in the GPF account. That is
GPF?
after retirement. All the amount has been paid. Direction may give him to state government to modify the roads.
No, but why did you challenge? You could have filed review application, modification, correction, and challenging the order as if some.
Yes.
Was OP number 3?
My lord, OP number 3 is the accountant general. In the writ itself.
When did he retire?
Petitioner retired in the year.
Petitioner, you cannot retire.
30/11/2014.
Huh?
30/11/2014. He retired from the government service with effect from 30/11/2014.
You can file modification or something. Why?
Liberty, your lordship.
Nothing. And counsel, assigning the order passed by a learned single judge of this court in court dated 13/10/2023, passed in WP bracketed OAC number 3493 of 2015. Learned counsel for the Accountant General, Odisha, has submitted that the learned single judge has wrongly directed opposite party number 3, the Accountant General, to for payment of GPF amount. Stop. The Accountant General does not have any such responsibility. Which amount could be paid by the estate only. Stop. Next. In our view, with such grievance, the appellant could have been well advised to make an application for correction / modification / review of the said order. So the appeal stands disposed of with the aforesaid observation in this intra-court appeal.
Item number 27.
Delay control.
My lord, item number 27 on behalf of Mr. Khalid, my lord. On behalf of Mr. Khalid, my lord, he is only placed, my lord. He will address, my lord. When next week, my lord.
Next.
Item 28.
28 made, please, your lordships.
Lordships, we are challenging the order of the Honorable Single Judge that is at page 103, my lords. Annexure 9. That's the operative part is at page 105, para 6. Considering the facts that the petitioners were not given an opportunity of hearing before dismembering, this court is of the view that the petitioners have been illegally dismembered by the Bar Association. Accordingly, the State Bar Council to take step to include the petitioner's name in the electoral roll so that they can participate in the Bar Association election 2024-25, and also they will get the chance to cast vote. Now, my lords, this has been passed under the impression that the petitioners were not given the opportunity of hearing. However, my lords, admittedly, the first petitioner in that particular writ application was not noticed. That is an admitted position, my lords. However, in respect of the second petitioner and the respondent number 4 in this writ appeal,
no, why such dispute should come to the High Court?
Such an order, because as per the rules, societies, all these election related matters is to go to the senior civil judge. I have taken that as a ground also, my lords. However, my lords, even though that
file these applications, you are not Swastik Rath.
No, my lords. I am the member of the interim committee. The committee, the body was dissolved, and the interim committee came into place, my lords. That is at page 32, my lords. I am a member of the interim committee of that particular
committee of what?
Of the Lawyers Association, my lords, the Bar Association. The Bar Association at present there, my lords. So the interim committee was formed, my lords.
Interim committee is still continuing.
Yes, my lord. Now the code of conduct has come into place, and the election officer is in place for the conduct of elections on 30th.
Otherwise, the entire thing has become infructuous.
No, my lords, the particular fact that the suppressing the material fact, they have taken that order from the Honorable Single Judge, my lords.
No, which order? So then you could have filed a review.
My lords, at that particular time, we didn't have, we were not a party in that.
Therefore, you can file a review.
My lords, due to paucity of time, my lords, the only difficulty, my lords, on our part is
we cannot entertain. Where is the question of you could have gone there, you could have got an order.
My lords, the difficulty is that since we were not made a party, the chairman in connivance with the petitioners therein
Maybe. Sorry. You can file a review.
My lords, I only pray, my lords, we are confining our arguments in respect of one person.
No, whatever.
The other person has not been due to paucity of the particular time, my lords, and the elections on Saturday, my lords. That's why we have
We will not do anything.
We have preferred this application.
The appellant claims himself who are you?
I'm the member of the interim committee, my lords. At page 32, my lords, the Odisha State Bar Council resolution is there, my lords.
To be a member of an interim committee
of Lawyers Association, Tangi.
of Lawyers Association, Tangi Khurda, constituted by the Odisha State Bar Council. He has assailed an order passed by a learned single judge of this court dated
7/3/2024.
Orders passed by a learned single judge of this court dated
07/03/2024.
7/3/2024. Stop. Some dispute was raised by the petitioners in the writ petition in relation to preparation of final voter list. Full stop. The petitioners had a grievance that they were wrongly dismembered.
Yes, ma'am.
By the Bar Association for the purpose of annual election of, for the purpose of its annual election.
Yes, ma'am.
Stop. Next, learned counsel appearing on behalf of the appellant has submitted that by suppressing material facts and without impeding the interim committee of the association.
Interim committee is a party there, my lords. However, the chairman in connivance, that is our whole problem, my lords. The interim committee did not, the chairman never mentioned to the members of what course of action was taken in
Chairman is which chairman?
Chairman of that interim committee, my lords.
And you are member?
I am a member, my lords.
So there were only 2 persons?
3 persons, 1 chairman, 2 members, my lords. That is the whole dispute, my lords.
Mockery of these things. That though the interim committee was met, party in the, we will impose cost. So the interim committee was impleaded as a party in the said writ petition, the chairman of the said committee did not inform about the filing of the writ petition and entered appearance without taking into confidence the members of the committee. Stop. Next. In our considered opinion, this intra-court appeal is not only misconceived, intra-court appeal based on the aforesaid grounds in relation to election of a bar body is not only misconceived, it is thoroughly frivolous and deserves to be dismissed with cost. First off, this appeal is accordingly dismissed
cost may not
with a cost of rupees 2,000 to be paid by the appellant in the account of which bar association is this? Which bar association? Bar association
Lawyers Association.
Within Lawyers Association, whatever. What is the name?
Lawyers Association Tangi, my lords.
Lawyers Association Tangi within 2 months from today.
My lords, I beg apology, my lords.
Sorry.
Cost may not be impossible.
Sorry. Just think of the
the
value of the time which you have wasted.
My lords, the genuine
of the court. Sorry.
So show cause was issued to one petition.
All right.
That is why we
you can challenge this order.
Confined.
You can assail this order, Mr. Counsel.
Item 29.
I'm grateful, my lords.
My lords, before I take my lords to the Annex 1, which has been impugned before this honorable court, I will give 3 dates, man. One is 22/1/91. Now, my lord, on this day, a disciplinary proceeding was initiated against the petitioner for misappropriation of 26,860 rupees. One date, my lord. The second date I am, my lord, I am submitting to my lords is he was deployed to Bargarh district on 25/3/95. Bargarh district. Was deployed to Bargarh district.
What was his post?
My lord, he was a revenue inspector, RI. My lord, he never joined. Then the last date, my lord, may I submit, my lord? 24/7/2000. He was convicted.
Yes.
In the case of under 409. He was convicted. He died on 29/2009. My lord, had he continued, he would have retired on 1/3/2012. These are the dates, ma'am. My lord, in such circumstances, the wife of the petitioner, wife of the petitioners of the deceased government servant, approached the tribunal in 2017. That is way 580C of 2017. Doesn't say that the husband is convicted. Suppresses this fact. 6 for pension, family pension. And my lord, this honorable court did not decide, my humble submission to subject to my lord's acceptance, did not decide the most crucial question whether he was entitled to pension because of the conviction. Decided and directed to, my lord, I will read the order to be exact, verbatim. My lord's directed that.
So whether a forfeiture of pension is automatic or some order is required to be passed in view of conviction under the rules.
My lord, under Rule 6, if my lord will kindly see that on conviction, he will not get pension.
No, whether that is automatic or whether any order is required to be passed in the light of the order of conviction. Conviction can be a ground for forfeiture of pension. One. Conviction can be a reason. Conviction automatically result into forfeiture of pension. That will depend upon the nature of the rule.
Exactly.
So what is the rule?
May I take my lord to Rule 6 of the Orissa Pension Rules 1992. May I read, ma'am?
Yes, please. Rule 6 will not apply.
Rule 6, ma'am. I will place only Rule 6 and read with Proviso 3. 6, 3, Sub-Rule 3. 6, 1 and 3. For the purpose of my case, if I can satisfy this honorable court, that on conviction, he will not go.
6 will not apply. Because 6 applies only to the persons who have already retired. This is subsequent future good conduct.
Yes, ma'am.
So he retired in?
He died in 2009.
No, he died in 2009. He died in 2000. His conviction is 1995.
Conviction is 2000, ma'am.
Sorry, conviction is 2000.
Yes, ma'am.
So conviction is 2000 before he died and before he could have retired.
Yes, ma'am.
When he was in service.
Yes.
He was convicted.
Yes, ma'am.
So in that background, whether Rule 6 will apply or not. Yes. Because Rule 6 will apply only for future good conduct post-retirement. Post-death, you cannot do anything. Future good conduct would mean that only, and thus read the whole body of the rule. if you read the entire body of the rule, you will realize that this is meant only for those who have retired. And this is the disciplinary control which the disciplinary authority shall be exercising for on those who have retired also.
My lord.
All right.
I'm aware because my lord because the word used is pensioner. That's why the word used is pensioner. 6.3, where a pensioner. But my humble submission to this honorable court will be subject to my lord's acceptance. If I'm to read my lord Rule 6 in strict letter and spirit of the rule, then my lord, my humble submission is if somebody is convicted, he doesn't get pension, even if there is no order to that effect.
In everywhere it is mentioned, there must be some order.
Well, may I humbly submit one thing,
It is not automatic. But there is Rule 100. Come to Rule 100. Rule 100 of Bihar pension rules. I remember the there must be a provision under the pension rules that conviction in a criminal case involving moral turpitude shall result into forfeiture of all past service for the purpose of pension. Whether there is such provision there or not.
That is the purport of Rule 7, man.
Yeah, let us see.
That is the purport of Rule 7, but
that is also
may I take my notes to Rule 7 as well. May I place Rule 7?
Yes, Rule 7 will also not apply. Read it.
Rule 7. Rule 7 actually, my lord, I must submit that it requires to pass an order. But my humble submission to this honorable court was relying on Rule 6. When, may I say, my lord, one thing? As my lords are looking at Rule 6 and 7, why I am aggrieved, my lord? I am aggrieved because this honorable court never decided the entitlement. My lord, that's why I am aggrieved.
Just a minute. Come to page 48 of this brief.
Well, as my lord is looking at page 48, may I take my lord to page 47, paragraph 3? Even though, may I read, my lord, kindly just take the previous page. Even though this court by order dated 1/3/24 directed for personal appearance of opposite part number 3, if no positive instruction is provided with regard to sanction of family pension in favor of the petitioner, but an additional government advocate basing on the instruction provided by the collector and district magistrate Burger contended that since the deceased employee was convicted in a criminal case by judgment dated 24/7/2000, he was not eligible to get the benefit of pension and other pensionary benefits, and accordingly petitioner being the wife of the deceased employee is also not entitled to get the family pension. Then comes paragraph 4, my lord, may kindly see. But it is fairly contended by the learned AGA that after such order of conviction and sentence, the deceased employee was never terminated from his service with passing of appropriate order in that regard. However, considering the request made by the learned additional government advocate list this matter on 20th March 2024, if by the next date no positive instruction will be provided with regard to sanction of family pension in favor of the petitioner, opposite part number 3 shall appear in person. My lord, I only humbly pray before this honorable court, if my lord should decide, yes, that in the absence of any termination order, the petitioner is entitled to family pension, my lord, we are duty bound to carry out that.
Then your prayer is to quash that annexure 5. Once you have considered and submitted certain things and you want to quash it in a writ appeal.
Well, not annexure 5.
Yes,
Annexure
your
1.
prayer, you come to prayer. Prayer.
Annexure 1. Actually, it is annexure 1.
No, you have made.
My lord, annexure 5
You
may
check
have
up.
been submitted.
You check up in your prayer.
My lord, it's not
You
exactly.
have mentioned about 2 orders, and annexure 1 and annexure 5.
My lord.
Yes.
My lord, annexure 5 may humbly submit, my lord. It is, we are conceding the factual position, my lord. It's not that we are not saying that yes, because he is not terminated, he will get.
So you have faulted with your fraud.
That is my humble submission. It was our submission that because of the conviction he will not get. Yes, we admit that there is no order of termination. And my lord, the writ petition was actually there was no order in his favor.
See, that question is twofold.
My lord.
One, entitlement to pension.
Well.
And 2, forfeiture.
Well.
So entitlement is apparent. Forfeiture is based on conditions as prescribed under the rules. So if there is some provision under the rules which has been followed by you, then it's all right. Otherwise, you'll have to pay. That is the law. You did not take any decision. Rather, some actions should be taken against your officials. Departmental proceeding was initiated when?
In 92, man.
In 92. And when did he die?
2009.
2009. In the meanwhile, the criminal trial could conclude, but you could not conclude your departmental proceeding. And you are denying pension.
No, because he was absconding.
What are you challenging?
So you could have dismissed.
What are you challenging? Annexure 1, production of the person concerned.
Yes,
That
because my lord, as I
SP is
said, my lord,
directed to produce person.
You have challenged that order.
Yes, that order is the challenge.
You have challenged that order, Mr.
Yes, annexure 1 is that.
my lord,
Annexure 5 he
subject to my lord's
considered.
acceptance. Subject. I am agreed where, my lord. I am agreed.
No
because
question
there
of-
is no entitlement, my lord. Entitlement has not been
Entitlement
fixed.
is. We will see.
And my lord,
Just a second.
my lord, kindly hear me after.
Think
that.
over again in the meanwhile,
My lord.
during the recess, fully.
Your Lordship, I may be pardoned to make a mention at this hour, Your Lordship. Your Lordship, I am a student of Institute of Chemical Technology, Bhubaneswar campus, Your Lordship. In the meanwhile, the university authorities have asked me to vacate the hostel, Your Lordship. I am a student of Maharashtra. I have been left remediless. In the morning hours, I had made a mention before the bench, Your Lordship. But however, the bench had asked me to mention before the DR. I have been informed that it will be taking some time for him to decide as to which bench it should go, Your Lordship. I request Your Lordship may take up the matter as it is pertaining to a student who will be left homeless, Your
All
Lordship.
right, it will be notified.
May I take my lord for a minute now to annexure 8, page 52.
Yes.
Well, we have, because of the order of the town of court, we have sanctioned the provisional, the family pension, provisional family pension, the pension. Has the pension sitting there?
Yes.
No. With reference to the subject handed above, and would say that Honorable High Court of Orissa has passed an order on 23/24 in WBCOC 580/2017, directing to understand the appealing person on the next date, pension 22/3/24 for non-sanction of family pension in favor of the petition. In order to comply with the appropriate order of the Honorable High Court, the understanding is inclined to sanction the provisional family pension in favor of the petitioner by order number such shortly enclosed. Hence, the Honorable High Court may kindly be apprised that the compliance of Honorable High Court's order is just the understanding in personal activities. Now, my lord.
No, when was the writ petition disposed of?
No, it's in pending, my lord. So, in the bond, my lord has directed to pay the family pension and to take positive and to provide that positive instruction to the court that it has been paid. It has not been decided now. That was my first submission to this honorable court. I said subject to minor circumstances. That it has not been decided. That's why I am agreed.
Where is the order?
You are agreed by order dated 11/3/2024.
And 22 also.
Before that also two orders have been passed. So that
You have challenged two orders.
well, unless you want. May I take
Now, first order is 11/3/2024.
Well,
From there it emanates.
page 47, my lord, thanks. May I read paragraph 2, my lord?
Page
47.
47.
No, but Mr. The question is very simple. He has been convicted. No action has been taken by you. The question is whether his conviction shall automatically result into forfeiture of his pension or not. For forfeiture of his past service or not, for the purpose of payment of pension. That is the only question.
Well,
And that will depend on the provisions under the pension rules. There is nothing like that.
it has not been decided. I demand where I am because it is not decided by this honorable.
No, you tell us. We are here to decide everything. We can call even the writ petition.
My submission to this honorable will be my most of in view of Rule 6. If we have to understand the Rule 6, the purpose of Rule 6 now, then
No.
order is not tested. That is my humble submission to this honorable. That yes, because there is a conviction and just because they have not passed any order, consequential order, dismissing him from service.
No question of dismissing him. You could have taken a decision that because of conviction, you will not be paying him his family pensions. He will not be entitled for any post-retirement.
Now, that I don't know.
Is there any provision? Is there any provision of automatic dismissal or removal?
That was my mistake. So that I am trying to answer now. In 2009, since he died, he would have got pension in 2012. So in 2009, he is died. The petitioner died. So there is the question of yes, entitlement of family pension.
Your conviction is in 2000.
2000.
So till 2009, you have not taken any step. No action is taken. 2009 he died.
Sir, this is an extreme case where you started a disciplinary proceeding in 1995. You did not conclude that. Criminal case was instituted. Criminal case culminated into his conviction. You did not do anything despite that. In 2009, he dies. And now in 2012, his wife has rightly come for family pension.
No, he came seeking only in 2017.
So what?
No. 17.
So what?
No. Our submission to the honorable court was, in view of the conviction, she is not entering. That was our submission.
How do you say?
That my lord will see, my lord will get it from the order, get it 11/3/20. That was our submission to the honorable. That
Mr. Counsel, your submission will have to be substantiated by something, some provision.
in view of Rule 6.
Rule 6 is nothing. Rule 6, just see the caption.
Where the pensioner is convicted.
What is the definition of pensioner? What is the definition of pensioner? So he was not a pensioner when he was convicted.
No, he was not.
So therefore, how can this rule apply?
Before he could become a pensioner, I have understood my mistake. Before he could become a pensioner, he had.
And particularly when there is specific provision under the rules, when you could forfeit his pensionary benefits. Rule 33 seems. Yes. 33 and 34. So conviction is not there.
Clearly 34 requires an order. On hearing, my lord, I have understood my lord's query and yes, I am not.
No, 33 doesn't require any order.
Dismissal or removal of the government servant.
This is automatic.
Yes.
This is what we are saying.
Yes, because there has to be order of dismissal.
Order of dismissal is different. Order of conviction, here it is a judgment of conviction. So these 33 and 34, these have automatic consequences.
Madam.
So resignation, dismissal or removal from service. These are circumstances and the rules are specific. Then you cannot deny it. All right, we will hear the writ petition also. We can take up all these matters.
On second.
Second.
On second of the
All right. But we are completely at a loss. We don't know what is the circumstance in which you are denying the pensionary benefits. Yes, Mr. Advocate General.
Actually, if your lordships kindly see, the pensionary benefit has already been granted. Kindly see page 52, my lord. Already granted. And this was granted on 21st of March 2024. So really speaking, my lords, the order has been complied. And on the very next day, my lords, on 22nd of March, the very next day, the learned single judge says that the collector will appear and the SP will bring him. And this is at a case, my lord, we are at an interlocutory stage. And your lordships have laid down the SOP already. It's not a case where there's a violation of court's order. Two things emerge, my lord. One is that at page 52, it has been.
No, we, at this stage, we intend to enter into the merits of the case.
Grateful. Grateful.
So if there is no reason to deny family pension, you grant.
Obviously not. My lord, ultimately, your lordships have to decide that issue.
So you think over. If you find anything, then it's all right. Otherwise, if she is entitled, you grant her and then come to the court.
My lord, your lordship may see page 52, already granted.
Not fine, provisional.
You are
Provisional.
only reason which emanate from orders or passed by single judge.
Yes.
The your denial is only boils down to only point that since he was convicted, she is not entitled to family pension. That is the only question.
My lord, what would have followed was a judgment by the honorable court, my lord, to say that you pay. Your contention is wrong, you pay. That would have been one conclusion. But notwithstanding that, a provisional pension has been.
No, let us forget for the present.
Yes,
all the proceedings,
fair enough,
including this proceeding.
Absolutely, great.
And the writ proceeding. Please think over.
Yes, ma'am.
And if she is entitled to,
my lord, if she is entitled, I take the responsibility, my lord, to come back to your lordships and say she is entitled.
Yes, that's all.
Great.
We will fix the matter after 2 weeks.
Anytime.
In the meanwhile, the
yes, I'm grateful.
That we can do. We'll list this matter on 2 weeks. Stop. The court expects that on the next date, the state shall take a fair and definite stand based on the statutory provisions as to whether the appellant, the writ petitioner, bracketed respondent number,
Respondent 1.
can be denied family pension in accordance with the provisions under the Odisha pension rules.
Grateful.
Stop. The court shall consider passing appropriate orders based on the nature of stand which the state takes on the said date. Stop. In the court further expects that in the event the state competent authority is satisfied about the entitlement of family pension of respondent number so and so, comma, he shall pass appropriate sanction orders.
My lord.
Stop. Till next date, the operation of the impugned orders dated so and so shall remain in abeyance.
Grateful.
Anything else?
Would my lord say 3 weeks? That's what
3 weeks.
Grateful.
And item number 30.
May it please your lordship. Lord, this is a matter, my lord, regarding land acquisition, my lord. Petitioners were denied the compensation, my lord, of their land since last 63 years, my lord. Last 63 years, my lord. The undisputed facts relating to this case is, my lord, the land.
May this stage intervene, my lord, saying that pursuant to lordship direction, I filed the affidavit stating therein that whether he is entitled or not, and whether the amount has been paid to him in pursuant to earlier in 1961, my lord. Because pleadings are completed, so many complicated things are to be. I prepare a short note, my lord. Lordship may only call it, my lord, third or fourth, my lord, so you can take it out, my lord.
My lord, opportunities were given for the last 17 occasions, my lord. They have filed the affidavit, my lord, by saying that there was no land acquisition proceeding upon the petitioner's land. This is undisputed fact, my lord. The petitioners, being the scheduled tribe persons from a backward district of the state, my lord, denied compensation. The construction was made in 1961, my lord. The state, my lord, since 1961 contended that yes,
Kadadi, you claim to be backward.
yes, my lord, yes, my lord, they are the scheduled tribe people, my lord, and the state has denied compensation, my lord. And the very fact is,
This
my
is
lord,
WPC 22841.
yes, my lord.
And after 50, more than 50 years, now the claim has been lost before the Supreme Court claim compensation, my lord.
No, my lord, that is absolutely wrong.
Maybe because there are development suits have been filed, everything. But I will bring all these facts to our lordships.
Just a minute.
My lord.
So you have filed your counter affidavit.
Yes, my lord.
You are not required to file any rejoinder to that.
My lord, what I humbly say, my lord, this is not the counter affidavit. They have counter affidavit filed long back, my lord. After that, 3 affidavits they have filed in compliance to the court's order. After that, my lord, in order number 10, they have specifically directed to file the compliance affidavit whether there is any land acquisition proceeding upon the petitioner's land. They have filed it after your lordship's order in order number 26. After the order number 10, lordship has specifically directed them. My lord, may kindly see the order number 27, my lord. Pardon your lordship. The paragraph number 3, my lord. The court takes serious view of the non-compliance of the aforesaid orders. If on the next date no affidavit is filed by the opposite party number 3 Tahsildar Dharmagad, the Tahsildar Dharmagad shall be required to be personally present before this court. When
So
this
they have
court,
filed.
They have filed, my lord. I did not go into that affidavit because that affidavit is clearly in favor of me, my lord. They have said in that affidavit there is no land acquisition proceeding upon the petitioner's land.
No, but he is seeking adjournment for sole purpose of preparation.
My lord, that is true, my lord.
Should not be denied.
My lord, that is true, my lord. Many last chance were given in this case. If your lordship
No,
will
no, last chance. This is
lordship may keep it to next week, but this is my contention, my
All
lord.
right, all right. This is what you want?
Yes, ma'am.
As requested by learned AGA, list this matter on which.
Item 31.
Obliged.
31 minutes. So this is regarding that, so virus of this amendment is being under challenge, and the lordships are directed to file the counter affidavit. My counter affidavit is ready. It is being filed in course of the day before the extreme loss. Lordship may also take it up. I will serve copies a week after so that it can be taken.
As lordship is this.
It is stated by learned AGA that a counter affidavit has been filed. This is going to be filed.
Today, in course of the
Is
day.
going to be filed in course of the day. A copy of which has been served upon learned counsel for the petitioner. Stop. List this matter on 1 week, 2 weeks. 2 weeks. Stop. Let the counter affidavit, which is going to be filed today, be placed on. The interim order shall continue in the meanwhile.
Much obliged.
Item 32.
32, your lordship, on last occasion, lordship, I heard the matter and directed the opposite parties as regard to take instruction whether any reason to deny the petition salary from the period of 24/3/09 to 33/9/2013. And also directed to pay pensioner benefit after giving pension papers.
Which item?
32 Your
32.
Lordship.
Jamini Mohan Mohanty.
Your Lordship. Kindly see last order dated 29/2/2024. Para 9.
Yes.
The petitioner submitted his pension papers accordingly in the last paid drawn, Your Lordship.
Then what is the
Final pension is not paid to the petitioner yet. Your Lordship directed the state opposite parties to pay the final pension and other later benefits by the next date. And as regards to the salary from the period, Your Lordship directed the state to take instruction in that matter.
on 23/3/2009, whether you were in service or not? That was the question.
Your Lordship.
On what is the relevance of this date?
Your Lordship, petitioner was actually reverted back. But since no post was available, he was relieved.
Please come to order number 11.
Your Lordship.
Oh, order number 12 takes note of the issue involved.
Your Lordship. Already submitted the pension papers. 6/3/24 received also.
So have you submitted?
Your Lordship, on 6/3/2024. As per the last paid drawn, submitted. Which I have submitted a copy.
Yes, come to paragraph 7. So salary you will have to pay. Next week. So confined to paragraph 7. 7 and 9. Yes. Two weeks further time is allowed for the estate in the state to address this court in relation to the issues raised in issues pointed out in the order dated 29/2/2020.
Pardon me, Lordship. It may be recorded that petitioner has submitted the pension paper on 6/3/2024 as per the directions.
Learned counsel for the petitioner has stated that in compliance of the aforesaid order of this court dated 29/2/2024, the petitioner has submitted the pension papers.
On 6/3/2024.
And let a set of copy of such papers be served upon learned counsel for learned AGA for him to seek instructions.
Oblige, Your Lordship.
Item number 33.
Lordship, I am appearing on behalf of Mr. S.B. General. Lordship, kindly see the last order of your Lordship. Paragraph 5. Lordship has directed to take instructions so far as double the amount of compensation in lieu of reinstatement, Your Lordship, of the petitioner.
My lord, we have. My lord. My lord, we are on principle, my lord, we are agreeable to the view as my lord, but my lord, in case, my lord, amount could be reduced a bit, if not. My lord. And my lord, they have taken the check of 2 lakhs rupees. And they may, we do not know they have encashed it or not. The difference amount we can pay, or if they can return the check, we can pay the.
So you both of you sit together outside the court,
Yes,
decide how to get the matter resolved, and then tell the court we can dispose that out.
It can be ordered.
Your Lordship, it can be disposed of, Your Lordship.
Very fair stand has been taken on behalf of MS Bata India Limited and another Bata India Limited bracketed opposite parties. It has been stated by London Council for MS Bata India Limited that it is ready to pay to the petitioner a sum of rupees 4 lakh.
Yes.
4 lakh. Which is double the amount, which was directed to be paid by way of compensation to the petitioner by the labor court. Full stop. In such view of the London Council for the petitioner does not have any objection to such offer made by the opposite parties, made on behalf of the opposite party. Stop. Next, in such view of the matter, without entering into the legal issues involved in the present writ application, this application stands disposed of with a direction that let Mrs. Bata India Limited pay to the petitioner a sum of rupees 4 lakh after adjusting the amount, if any, already received by him.
Yes, sure.
Within how much?
4 weeks, my lord.
Within a period of 4 weeks from today.
Yes.
So stop. This application stands disposed of. Stop. We put on record our appreciation for the endeavor made by Mr. P. Verma.
Yes, ma'am.
Mr. P. Verma, London Council, who represented Mrs. Bata India Limited to get the issue resolved amicably.
Well, oblige, Lordship.
Oblige.
Item 34.
For missing also, we may impose cost. How can you miss such a valuable document?
Unfortunately, I have misplaced it somewhere. That is why I.
All right, all right. All right.
To next week. Keep it to next week. Just now, I have already. Any date next week or last week.
As requested on behalf of the petitioner, list this matter on 2 weeks.
Yes, yes. For writ appeal, there may not be necessity.
Huh? No, what has happened?
40 color. Yes, put it switch.
No, this thing. Put the switch on.
No, no,
It's
starting.
coming.
So here is the.
Oh, it seems I pressed it. Yes.
Yes, now it is.
35.
We lost it from the last order, directed the Director of Secondary Education to take a decision who will pay the back wages, 75% back wages, whether by the managing committee or by the educational authority. We lost it by the order dated 29/2/2024 as directed so. And last, in the facts and circumstances of the case, we direct the Director of Secondary Education Odisha to take a decision in this regard after giving the managing committee an opportunity of hearing and inform this court within 3 weeks from today, my lord. Till today, managing committee has not been noticed by the director. These are aided educational institution and the government is to bear the entire salary of the.
No, what happened? The district, whether he
They
has
have
taken
not
it?
issued notice to the managing committee today. Director has not issued notice.
Tuesday, let it come. Wednesday. Tuesday, I may not be here. Sorry. Yes. As requested on behalf of the estate. As requested by Mr. AGA representing the state of Odisha. List this matter on third. For him to seek instructions as regards developments subsequent to this court's order dated 29/2/2024.
No, 36.
That in this matter, the lordship kindly see order dated 12/3. Then single judge reserved the orders, my lord.
Yes. Is it the order?
Orders reserved.
Where is the order?
12/3, your lordship directed awaiting the orders of the land single judge. Land single judge heard the matter and reserved the orders.
12/3/2024 order.
Not yet pronounced.
12/3/2023 awaiting the decision in writ petition. List this matter on 28/3 today. So hearing is concluded.
Which is order? Which order?
Order number 16, 12/3/2024.
hearing period. Millard. This is Millard regarding.
So we can adjourn it for
Yes, yes.
further time.
Yes, some other.
Learned senior counsel representing the appellant has informed this court that judgment in WPC number 16810 of 2015 has been reserved after conclusion of hearing. Stop. List this matter on 8 weeks, waiting the decision in the said case.
18.
8 weeks. 8 weeks.
Millard, it can be already odd, Millard. Let it come after 2 weeks.
Lord, let us see. 2 weeks. 4 weeks. 4 weeks. Max.
We cannot say.
4 weeks we can't say,
4 weeks.
We can't say when judgment says.
Item 37.
Right, 37. Where files are updated, we have also solved problem. And this matter may kindly fix at 2 p.m. every 2 p.m. every day.
How many cases are there? How many cases?
There are 6 cases. One in the list, another 5 are there. Two in the list, my lord. My case is there. Two in the list, my lord. My case, one case is there, my lord. Two in the list, another 5 are there.
Item number 37.
37.
37. 37, there are only 2 cases.
Yes.
See. All right. What is the issue involved?
Merger of the school. To some extent, my lord, starting.
What is that again?
Merger of the consequently leading to further some. You let us know, and any day next week, my lord, subject to 2 p.m.
Because this was that case where there are around 100 odd writ petitions disposed of.
147.
147. They have come up in writ appeal in 1 or 2 of them. That is one. And second is whether they can have a policy which runs contrary to the rules, the central government rules and the state rules. The single judge has given a specific finding that
So
your
we can
policy.
fix a date for final hearing.
Madams, they have some difficulty today. My convenience note also, I have made a very short note. It's there on record already.
So which date?
May I draw your lordship's kind attention? Last week, your lordship with the
29th April. So we are fixing it for 29th of April. 29th of April. 29th is Monday. At 2 p.m. At 2 p.m.
on 7th, my lord specifically directed the state to take instruction. How many appeals they have filed beyond this?
How many?
Appeals they have filed beyond the appeal they have.
See, you don't insist on that. Otherwise, they would file their appeal.
No, my lord, your lordship's query was there. Your lordship's query was that. That was the your lordship's.
Don't give them a hint. And you have already done that. So let us see how many appeals are filed in the meanwhile.
They are going to make it. That's it.
29. क्या हुआ? What happened? You are? You are supporting or opposing?
Opposing.
All right, we will hear you.
Sir, please
Give me 1 minute.
Come on 29. Please come on 29th April.
Sir, new education year starts from 1st April.
What start?
New education year starts from 1st April.
No, but this was filed in 2000 when? 22.
21.
So let us hear all those matters. We'll hear you all.
Government misleading the High Court and
We will see. We will hear you. If the state government is misleading, then here is senior counsel, other counsellor, senior counsel, experienced counsel, all of them are here to say that state government is misleading.
no, sir, they are not opposing.
They are not opposing.
No, sir.
All right. We will hear you on 28th.
Sir, despite the stay order, they open by.
See, we are entertaining you because you are appearing in person. All right. Otherwise, we know the ways and means also. Please come on 28th. 29, sorry. 29.
It's only one request, my lord. Can it be a little bit earlier? Because
Other matters are fixed on other dates at 2 p.m.
I was told by the government that they are agreeable for sometime next week.
Next week.
They wanted an accommodation, but
But we may have some
Let us see.
diary.
Let us
if it can be, because
let us see. We don't have any problem.
the learned AG was agreeable for any date next week.
On 15th.
15th.
As your lord.
15th April.
15th April.
15th too. We are all grateful to you.
Item 38. $38.
What is this the matter about? Of laboratory technicians. So we have today also we have more than all right. All right. Wednesday we are not fixing 2 p.m. It is likely that it will be taken up say at 3 and then we will.
Yes, ma'am.
As all right, as requested on behalf of the state, this matter on Wednesday. Third.
Mention minor.
I have got other 7 matters. I pray that those other matters may be listed in which I am appearing.
Yes.
I am appearing for the respondent.
Give us.
Item 39. In 39 also same prayer. 39 same prayer.
39.
39.
One minute. Lordship, Wednesday 2 p.m.
Item 40.
May I please?
Yes.
There are 3 appeals, but a common judgment. So, may I pray, my lord? Serial, the 3 cases, 3 different writ petitions with 3 different prayers I have filed. All were dismissed by a common judgment. So, for convenience, may I pray, my lord, writ appeal number 137 of 23 may be taken up so that all the same annexes only, but I have marked it so that it will be easier for me to con.
137.
137. In time.
Second one.
Again. I have
You have furnished, you have furnished one note.
Yes.
That is tagged to item number 1. Anyway.
137 to the last time I have read it.
Yes.
Scan
Scan.
You have given one set.
Yes.
Since that is number 1 item, that is tagged to that and that is scanned in our copy. So in the second sub item, we do not have that copy. So we will.
So kindly have that. That time,
anyway,
without going into the documents, also I can demonstrate the facts, man. Before opening the brief, there are 3 writ petition I have filed. WPC 7301 of 2015 I have filed. The first one. WPC 7301 of 2015.
So this gives rise to which appeal?
This one relates to this 137. 137.
Then
WPC 38079 of 21. 38079 of 21. That relates to writ appeal 166 of 23. Then the third one is WPC 2807 of 22. That is related to WA 182 of 23.
So one writ petition was filed in 2015. Other was in 2021 and the third in 2022. Yes.
But all are interconnected in this sense.
What is the order?
Yes.
The order is common.
Order is common.
What is the date of the order?
The judgment is at 9/1/23. That in this case, that will be at annexure 6, page 224.
9/1/2023. And what is the appeal which arises out of this 2807 2022?
2807 my lord 182.
Oh?
Of 182 of 23. Writ appeal.
Yes.
Lord, before I am to go into this fact, one of the fact involved in this case, because there are many other issues. But the Honorable Court has not gone into those writ petitions and their prayer specific and the judgments I have relied upon. It has decided this issue was with regard to who will be the principal in charge of a particular institution initially in 2015. There, my lord, a government circular was in vogue at the relevant time. That if a person, even if he is senior, if he forgo his right by a written unwillingness,
then he is forgone it for all time to come. That is why this present petitioner was allowed to continue as principal in charge of that particular institution. Initially, he is a lecturer.
Please come again. What did you say?
I say, my lord, in the aided institutions, there is no post of principal as such.
In adult institution.
Aided education, non-government aided institutions, or in the private institution also, there is no post of principal created or sanctioned by the government. What they have managed is, they have appointed the senior most person as principal in charge, and they manage the affairs.
No, but aided institutions are privately managed.
Privately managed, but receiving aid from the state government.
Yes, yes.
That is why government has issued a policy that you cannot appoint a principal on your own. Only the post is to be managed by a senior most teacher of the institution. But thereafter, they have issued a circular that if there are 3 persons, suppose 1 and 2 given a written unwillingness that we don't want to hold that post of principal in charge, the third man can be appointed as principal in charge. So that circular says, if you have given an unwillingness, then it is for all time to come. You cannot come back and say, no, again, I will be the principal in charge of that institution. This is what the first writ petition was filed in 2015. There was an interim order. And the case,
Filed?
pardon?
Who filed?
I have filed, because the junior was the person who has given an unwillingness, he has been allowed to continue again. I was the principal in charge, because the senior most person has given an unwillingness.
What is your name?
My name, petitioner is Ramesh Chandra Sahu.
Ramesh Chandra.
Right.
So Ramesh Chandra was the third person.
You are the second person actually.
Second.
Yes, your other person has given an unwillingness.
First unwilling.
Yes, Arun Kumar Chandan, who has given an unwillingness, is the opposite part number 4 here, respondent number 4 here in this appeal.
Yes, then what happened?
My lord, what happened actually? So this was the position. On the same date, on 9/1/23, this case was disposed of by the Honorable Single Judge with this same issue. Another writ petition was filed by another set of persons. Has nothing. But the issue is one and the same. Another added institution. This writ petition was dismissed, whereas the other writ petition was allowed. The counsels were the same, and the law, almost the argument was same. Other judgment was allowed by the same single judge. That judgment also I have annexed. The issue I have stated, my lord have taken note of.
That relates to some other.
There is another institution, another party. Same argument, same. I was the counsel. So the judgment was delivered in one date, that is on 9/1/23.
There is similitude in facts.
This is the issue. What I have stated to my lord, that is the issue. So whether if a person has given an unwillingness,
facts are different. Law is same.
Issue is same. Point of law
is same.
Yes, madam. So this case was dismissed. But the other case,
law may be same, issue may be difficult. Issue will depend on the facts.
my lord, the facts, as I have stated, my lord, only facts, it is different. In this sense, persons are different. But there is also another institution that a junior was allowed to continue because the senior has given an unwillingness, and she was also the principal. And it was altered by the government. That was challenged. But the judgment was delivered.
Your petition was filed in 2015.
15, 21, and 22, 3 writ petitions.
You filed 3 writ petitions.
Yes. A different issue. First one was for the seniority and this principalship, my lord. The second was with regard to my suspension, because that was passed by a person without jurisdiction, having the authority. He was not the governing body, because here the governing body is the authority to place a person under suspension or proceeding, initiate any proceeding. That is the governing body is the authority. But a person other than the governing body has passed that order. That was the ground of challenge in the second writ petition.
So you are still in service?
I am in service. That suspension is, because of the statute, my lord, that suspension doesn't hold good now also.
So this suspension proceeding has become infructuous?
No, my lord, because now by virtue of the dismissal of the writ petition, I have not been reinstated. And the Honorable Court has not held anything with regard to my challenge. I have challenged the order of suspension.
You are already in service.
Pardon, madam?
You are saying you are in service.
No, I am in service, but under suspension. I am in service.
You wanted to know.
Pardon, madam?
This is why you wanted to know.
Yes.
You said your suspension order has been vacated.
No, I'm not. Maybe wrongly acted.
All right.
Well, so My first submission is, my lord.
Second is suspension.
Yes.
Third?
Third is the proceeding. Institution of a department proceeding against me by the sub-collector who has no authority in the matter. He is not the governing body.
Huh?
He is not the governing body. Because only as per the statute, my lord, the governing body can only proceed against me.
All the three applications were heard together.
Mine.
Yes.
And but it is all these two issues with regard to suspension and the proceeding, the Honorable Single Judge has not dealt it. It has been proceeded along with as on the first issue, that whether you can be allowed to continue as a principal in charge or not. So therefore, I have referred to the other judgment. I have annexed that also. That is there. One other case has been allowed on the very same date by a different judgment. And this particular case was dismissed. That I have annexed it as page 271.
So when were you put under suspension?
My lord. Now I have a date check.
Let us see the rule first.
My
provision.
Well, kindly have a glance to the recruitment rule at page 976. That book, 976.
76 or 74?
976.
That is 74 rules.
Yes.
Yes.
The Odisha education.
976 pages.
Yes, yes. That is the Odisha education, recruitment and conditions of service of teachers.
So you are relying on which rule?
Yes. Rule.
No, which rule of that? 21.
Mile. Disciplinary authority. At page 992.
Yes.
The director may impose any of the penalties specified in Rule 20 on any employees, provided that director shall not initiate any disciplinary proceeding unless the managing committee or the governing body, as the case may be, refuse or neglects to take disciplinary action against any employee. Without prejudice to sub-rule 1, but subject to provision of sub-rule 3 and 4, any of the penalties specified in Rule 20 may be imposed in respect of a lower grade employees by the headmaster or the principal, as the case may be, in respect of any other employees by the managing committee or the governing body, as the case may be. Provided that in case of suspension of an employee falling under clauses A and B, the prior approval of the inspector in respect of any employee serving in a school and the director in relation to any other employee.
So governing body, in fact, as per Rule 21, it is not that the director can pass order only on the basis of the decision of the managing committee or the governing body.
Yes. The procedure is there. Rule 22 detailed procedure is available. Unlike CCA rule, that Rule 22 is the procedure. The director has a rule. Rule 22, kindly have a glance. Proceeding for imposing major penalty, and the 23 is minor penalty. 23, unlike CCA rule, my lord, this rule is there. The director has only the rule. After inquiry and everything, the papers will be submitted to the director, and the director has to give his approval. Approval or disapproval, whatever he thinks, deem fit. And thereafter, if an penalty is directed to be imposed upon an employee, then he can approach the state education tribunal against the penalty. But here we are on the previous stage, whether the proceeding can be instituted by a person other than the governing body. That is my case.
It is really clear from the proviso to Rule 21.
21, yes.
The director has that jurisdiction.
Director has the jurisdiction. Yet the director has not imposed that punishment. Here, in my case, director has not imposed any punishment. It is somebody else, man, the sub-collector, who has no authority in the matter. Here, the director can impose a penalty on an employee as per the statute, my lord, if the governing body failed to discharge its duty. In that contingency, director can pass out. But that is not the case here. Let me place my date charts, my lord, to appreciate the facts first.
So who had put you under suspension?
The sub-collector.
Sub-collector?
Sub-collector, who claims to be the president of the governing body, but he has not been approved as such. The law, division bench judgment of our own High Court is, unless the sub-collector is approved as the president governing body along with the other 15 members, he cannot function and discharge the duty. He himself stepped into the shoe of the governing body and placed me under suspension and also initiated proceeding against me. That is the bone of contention.
What is the opinion of the learned single judge on this?
No opinion on that issue. Only single judge has proceeded only on the first issue, whether this the unwillingness given by the other person. Because there are some allegation against me with some criminal allegation against me. So you are not to be allowed to function as the principal in charge. The decision is good. That is, he has not gone to these two aspects. These two other three writ petitions with three different prayers. He has not virtually gone into the other two, the suspension and the jurisdiction of part of the claim I have made. That he has not gone into. May I place the facts?
Who is appearing for the other side?
Other side, my lord, now the Arun Karma Chandan is represented by my learned friend. He is no more, he is also the principal. Now somebody else has been appointed as the principal in charge, as I have been instructed.
So notice will have to go in this.
Notice it is gone. My friend has appeared.
I have appeared. I'll assist your lordship so far as this writ appeal 137 is concerned. That is directly on the issue as to who will be the principal in charge.
Yes.
So far as the writ appeal number 182 is concerned, that is possibly only relating to his service conditions. So I may not have any say in the matter. The government and the governing body will have say in the matter.
Who is representing the governing body?
And
in fact, my lord, there is no approved governing, as my instruction goes, there is no approved governing body as a date. So therefore, as per the statute, my lord, under section 7.
Who governs you?
Pardon, my lord?
Who governs you?
Yes, as per the statute, since there is no approved governing body, a governing body tenure as per this rule is 3 years. If there is no approval, under section 7, the prescribed authority, here the prescribed authority for the degree college is the regional joint director. So he is to appoint a person or body of person or the outgoing governing body to function. But as my instruction goes, my lord, there is no governing body as on today.
Then why are you working in such school?
So that the difficulty now
you don't have governing body, you don't have anything, you don't have, then why you work in that school?
No, in all of, my lord, there is any writ petition of the before the honorable single judge, another writ petition, my lord, because we are doing regularly these cases. The direction has been given to the government to constitute the governing body for the institution because these type of litigations are very often coming. That's the difficulty we are facing also. The clients are suffering.
So who should be here for your case?
Well, because now it is the director or the government functionaries, they are under the statute, they have to function. Or they have to appoint somebody.
Function as the officer of the department, not as the governing body.
No, they have to appoint a person.
Huh?
They have the state authority has to appoint in such type of contingency. They are not doing that. We are suffering. They are not. And shall I read the provision, madam?
Maybe. Yes.
7A.
7.6.
7A is the first provision. Kindly see 7A.
Let an affidavit be filed on behalf of the state of Odisha as to whether there is any governing body of which institution?
My lord, this is Hira Nila.
Degree Mahavidyalaya, Vishwanathpur, Kalahandi.
In accordance with the provisions under also rules 1974.
No, that governing body is section 7.
Rules.
Odisha Education Act.
Odisha Education
Act.
Rules.
My lord, we refer to page 136. 136 page. My lord, will get that provision.
Odisha Education, Recruitment and Conditions of Service Teachers and Members of the Staff of Aided Education Institutions, Rules 1924. This order is being passed in the review of submission advanced on behalf of the appellant that the state of Odisha has failed to constitute a governing body in accordance with the terms. Let us see.
Yes, in fact, what my friend wants to say that the sub-collector has not been appointed in accordance with the procedures, so therefore he is not the president. It's not that it's not there, but let my friend find out. That is essentially he says.
Not
Let us see.
You are no way affected.
No, he is no more there.
Assisting.
He is no more there in the post.
It's not that, I'm just assisting.
Because he was a party in the writ petition.
Yes, he is nice on his part that he is here. Otherwise,
Yes.
he would not have come.
I'll also assist on the point who is the principal in charge of that.
My lord, kept it to
2 weeks.
Item 41.
Item 41, my lord. The state is the appellant here before my lords.
Yes.
The judgment dated nine 5/23 at annexure 3. My lord, that starts from page 44. Is under challenge before this honorable court. May I take my lord to page 44, please? My lord, sir, page 44.
Yes.
My lord. As before I take my lords through the judgment, here was a claim. The petitioner claims, writ petitioner claimed before this honorable court that he has done some work, my lord. He has executed some work for which the required remuneration has not been granted in his favor. It was disputed in the counter. So my first submission to this honorable court would be, is my lord, it being a monetary dispute claim should not have been entertained by this honorable court. Number one, my lord. Number two, my lord, my second fold of submission is that the writ petitioner having suppressed material facts before this honorable court was not entitled to any relief. Even this is a court of this being a court of equity, my lord. Even if he had a
What had he suppressed?
yes, ma'am. The relevant, even the honorable single judge has taken note of that submission of the state council, ma'am.
But your stand is that that single judge has not taken into consideration your stand taken in the counter.
Ma'am.
So what is that? You have taken a stand, firm stand, that single judge has not taken into consideration. You refer to your counter paragraph, which is not taken into consideration, and
Which part of the counter affidavit, or which part of your stand, or which stand of yours was not taken into account by the learned single judge?
Ma'am. Now,
In the writ appeal, my lord, I have annexed the counter affidavit filed before this honorable court. That starts at page 23. May I take my lords there? May I take my lords to page 26
Of the writ.
of the writ appeal, my lord. I have annexed the counter. So
You have annexed the counter.
I have annexed the counter.
Page 26.
Page 26, ma'am.
Yes.
It is pertinent to mention here. I'm reading the third line, ma'am, page 26. It is pertinent to mention here that on the basis of the application of the petitioner, a work order dated 1/5/2012 was issued in his favor by the opposite part number 3 as at Annex 1 series to the writ for excavation of a multi-purpose pond under MGNRES. That is, my lord, Mahatma Gandhi National Rural, that
Manrega.
my lord, with an estimated amount to the tune of 1,15,000. Accordingly, the opposite part number 4 had moved to the proposed excavation site and contacted the petitioner to give the layout of the excavation work and to intimate the Gram Panchayat office to deploy manpower job card holder for the excavation work as per the norms of the Manregas. But the petitioner was reluctant to start the work, to start the excavation work. Then due to self-illness, the petitioner had also intimated the said fact to the opposite part number 3 in his representation dated 8/9/14. My lord, I am taking 3 for relevant facts. Then I will exactly draw my lord's attention as to how we are agreed, because this contention was not dealt with by the honorable single judge. Then, my lord, page 27. Subsequently, my lord, got it. Subsequently, basing upon the representation dated 8/9/14 of the petitioner as at Annex 8 with the reply, a fresh work order
He
was
was in the fact, this is a fact admitted, that some work was allotted to him
my lord.
for him to execute.
Yes, ma'am.
He had executed also.
That is disputed.
How? So he did not execute anything.
Yes, that is our stand. He has not executed. What he has done, my lord, he has got, there are 2 schemes, my lord. This is one.
What was the work?
That was, my lord, there are 2 schemes. One is under Mo Pokhari, that is Panchayat Raj, and another is MG Manrega, which we are now doing. What the petitioner has done, he has availed a scheme under Mo Pokhari Yojana, and he has got the money. Now the same excavation he wanted to show to us under the Manrega, and he wanted that money. We found that out. That is why even affidavit before this honorable court, on the latest I have filed an affidavit that a team went there. The petitioner didn't allow our team person to visit. That whether actually you have excavated any pond under this scheme. And my lord, yes, my lord, it's a fact. We have not cancelled that order. That's a technical. My lord, we have not cancelled. I cannot escape from the truth. But fact is that you have availed same Pokhari, same under another scheme of Panchayat Raj department, and you want to show that by
So how much before that, this event?
Only, my lord, 1 year before. And in our report before, on affidavit before this honorable court, we say that there is no second pond. And my lord, this honorable court, on the submission of the petitioner that it was not cancelled, directed for payment.
had you done?
My lords. My lords, in the recent affidavit filed by the state, my lord, they themselves have admitted that there exists two number of pounds, my lord. The lordship may kindly have glanced that additional affidavit filed by the state on 9/2/2024, page 9, my lords. There they have admitted the recorded land is under Moses Siundi Khata number.
Just a minute.
Sorry. Annexure 4, page 9. To the
9/2/2024, they have filed. What is the affidavit?
Reply to the counter affidavit, what they have stated.
Reply to the counter affidavit. Right.
Page 9, your lordship.
Paragraph?
Your lordship, page 9, that is the inquiry report, my lords. Page 9, annexure 4.
Like D.
Reply to the counter. Reply to the counter affidavit filed by the respondent. That is 8 pages.
My lords. Yes, my lords. 8 pages.
Muralidhar Jana.
My lords.
This is your.
My lords, that is their reply.
Muralidhar Jana is Joint Director, Coastal Directorate of Fisheries.
My lords. That affidavit, page 9, annexure 4, my lords.
Annexure 4 enclosed by them.
My lords.
Is?
Page 9, my lords. Shall I please? Towards the last paragraph, my lord. Accordingly, the RI Rahama has conducted field verification on 14/1/2024 and from his report dated 16/1/2024 and trace maps, it is learned that.
So you are reading page 9?
Pardon, my. Yes, my lord.
Page 9,
Page 9.
paragraph.
Page 9, that is the inquiry report towards last, my lord. That is the.
In this connection, the Tahsildar requested to submit.
I'm placing it. In this connection, the Tahsildar Kujanga has been requested to submit an inquiry report after joint field verification of scheduled land under Mauza Siundi, Khata number 56, Chakka number 10, plot number 587, and measuring an area of acre 2.18 decimal wide. This office letter number 44 dated 12/1/2024. Accordingly, the RI Rama has conducted the field verification on 14/1/2024 and from his report dated 16/1/2024 and trace map, it is learned that the following are the findings, matters. The recorded land is under Mauza Siundi, Khata number 56, Chakka number 10, plot number 87, wrongly mentioned as plot number 587 in the High Court petition, having an area of total 2.18 decimal. One small rectangular pond having acre 0.20 decimal, length 100 feet and breadth 90 feet, situated over this plot number 87. Your lordship may kindly turn to the next page, while that is page number 10. That is the last point. Over this plot, another derelict weed infested earthen tank with an area of acre 0.05 decimal is present at a distance of 100 feet towards south direction from the pond of acre 0.20 decimal. So it is not a case that there is only one pond. There are 2 ponds exists.
It's 2 ponds in the same plot.
Same plot.
Right?
Well, sir, there, at the time of application, my lord, there was no stipulation that a petitioner cannot afford 2 different ponds for the same plot under 2 different. My lord,
who are you?
I am a villager, my lord. My lord, the first pond which the petitioner availed.
No, why was the work order given to you? Was there any process adopted?
Well, sir.
Why was the work given to you? Was there any procedure adopted?
Most petitioner had applied, my lords, and after that they have issued the work order, my lords. Because, my lord, the first pond which the petitioner had availed, that is a personal pond, very small pond. That is for personal use. This pond is not petitioner's personal use pond, my lord. It is a multi-purpose pond for pisciculture also. For? Pisciculture, my lords.
Pisciculture.
My lords. That was a personal pond.
Their allegation is
my lords,
that whereas one pond was already existing under Manrega, you, according to you, you got dug another pond, which according to them was never dug. That was the only pond. So, and you admit that out of the 2 ponds, 1 pond was your personal pond.
That was availed earlier, my lords.
Availed earlier, raised the question of availing earlier.
Well, so that is the finding, my lord. So that is, your lordship may kindly have a glance at. I am placing it from the order of the honorable single judge, my lord.
No, the second pond has been dug for whom?
For PC, that is not petitioner's personal use, my lord. Respondent's personal use.
And first was for your personal
use.
That was under the scheme.
No, that not same scheme. That is under another scheme.
Another
That was,
scheme, but no, that was not for public.
no, my lord, that is not.
It is more pond.
More
More pond.
Pokhari Yojana, my lord.
Mine. More means mine.
So you could have filed a suit.
Sir. Once the petitioner approached the opposite party for disbursement of the bill, and thereafter the petitioner approached this honorable court. And after the direction of this honorable court, the appellants have prepared the report in the year 2019. Their stand is that they had conducted the field inquiry in 2015, and thereafter they remained silent. They never cancelled the work order. They never intimated the petitioner
So
about
the
the
work order is important, or the work itself is important for the purpose of adjudication?
Work is important and work has been done, my lord.
So if you do some work, you will be entitled to payment.
My lords.
So work will have to be proved.
My lords.
You are saying that you had dug. He is saying you had not.
That's why they conducted a field inquiry, my lords, at the stage of the writ appeal, my lords. They themselves have conducted, my lords. And from their inquiry, it is found that there exists two number of ponds. Their only stand was, earlier their stand was that single person cannot avail 2 ponds. That has been clarified by the Honorable Single Judge, my lord. If your lordship permits, I'll place it, my lords. Shall I place it?
Place it, but since prima facie we are of the view that it involves disputed question of fact, we cannot go into. It's a kind of money claim.
Well, I admit that there exists. I have availed another pond and I have availed second pond, my lord. And their stand, earlier their stand was, I cannot avail 2 ponds. Now their stand, they have changed that there only exists 1 pond only, my lord. In their counter, your lordship may kindly have glanced at, if your lordship permits, I'll place. They have said that no, the petition cannot avail 2 ponds for the same land. Same land. Now their stand is not there. He has only excavated 1 pond and claiming and showing that he is claiming money for another pond.
What is the area of the plot?
Yes. Area of the plot, 2 acres, 18 decimals. The required land area was 67 decimals.
Belongs to you.
My lords.
That is the most important question my lord asked.
Only.
No, my lords, that is not for my personal use.
Then
that is also used by other persons.
Land belongs to you.
No, land
Recorded
belongs
in
to
your name.
My lords, that
One patch carving out of that 2.18
we are not convinced.
decimals of land.
My lords.
You have utilized some portion, small portion, around 20 decimals.
My lords.
For
this multi-purpose tank for pisciculture, my lords.
So only 20 decimals you have allocated for multi-purpose.
My lords.
That is under Manrega.
My lords.
So major part, you have owned another pond by utilizing government fund under more ponds.
More property.
So brilliant idea.
We are not convinced.
Well, my submission before you is that at the time of application, there was no stipulation by the opposite party appellants that a person cannot able to.
You had the cake and ate it too.
Pardon, my lord. And that is the categorical finding of the honorable single judge, that there is no the guideline which the appellants are relying upon. There is no such bar that a person cannot avail 2 ponds, my lords. That is my only submission.
All right. We are not convinced.
Stand by my learned senior that it has not been dealt in the judgment of the learned single judge. It has been dealt, my lords.
No, it has been dealt with.
My
Both disputed questions. the respondent had claimed disbursement of bill amount to the tune of rupees 1,86,000 for excavation of a multi-purpose tank over his land in question for PC culture, which was rejected by, who is opposite party number 3, who was rejected by the district fisheries officer
Number 3, my.
Jagat Singhpur. The district of Jagat Singhpur. Grieved by the rejection, the petitioner, the respondent approached this court by filing a writ petition under Article 226 of the Constitution of India, giving rise to WPC number 13725 of 2021. The petitioner asserted, the respondent asserted that the district fishery officer had issued a work order in his favor on 1/5/2012 for excavation of multi-purpose tank with an estimated value of rupees 1,15,000 over his own land in question for PC culture, which was excavated over the land appertaining to Moja Siundi,
my lords.
Siundi, 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 comma, khata number 56, check number 10, plot number 587, and measuring 02.18 decimal. Full stop. It was the petitioner also asserted that the work was completed before 31/5/2012 with the assistance of Gram Sathi, italics and job card holders, as the work was to be executed under Mahatma Gandhi National Rural Employment Guarantee Scheme, bracketed MGNREGS in short. Full stop. So in 2015, the estimated cost was enhanced.
Yes.
After you had executed the work.
Well, I had executed, but they were not satisfied with the work. So they insisted me to redo it so that they can disburse the amount. So they again issued a fresh work order in the year 2015.
Further, the estimated cost was subsequently enhanced to 1,87,000 with an assurance that the amount shall be disbursed after completion of work. So the petitioner asserted that he completed the work before 35/2015, awaiting 35/2015, is still awaiting disbursement of the final bill. Stop. He kept on representing the authorities for payment of bill, but of no avail, according to the petitioner. Stop. This is the background in which the petitioner is the respondent. Respondent is said to have approached this court seeking direction to the state opposite parties for payment of a sum of rupees 1,86,000, being the value of work executed by him. Stop. Next. Counter affidavit was filed on behalf of the state wherein it was asserted that a work order was issued on 1/5/2012 by the district forest officer for excavation of the said multi-purpose pond, whereafter the who is the opposite party number 4 was there in the writ petition.
And opposite platform 4 is the
Fisheries
extension of Pujam.
District
Jagatsinghpur.
Fisheries
extension officer.
Thereafter,
Pujam.
the fisheries extension officer,
Pujam.
Sir Kuzam, bracketed OP number 4 in the writ petition, had moved to the proposed excavation site and had contacted the petitioner to give the layout of the excavation work. First off, the petitioner was, however, reluctant to execute the work, start execution of work because of his own illness. Was intimated to the district fisheries officer in his representation dated 8/9/2014. So the said representation was brought on record by way of annexure A/3 to the writ application. The respondent had requested the district fisheries officer to cancel the work order dated 1/5/2012. Stop. It was accordingly the case of the respondents in the counter affidavit that it was incorrect on the part of the respondent to have taken a plea that he had completed the work before 31/3/2012. Stop. It was also stated in the counter affidavit that based on a representation dated 8/9/2014, a fresh work order was issued by the district fisheries officer with a revised estimate to the tune of rupees 1,86,000 for the excavation of the multi-purpose farm pond under Manrega MR MG GS scheme, the GS, having water area of 0.50 acres. Acre over the same piece of land. So stop. It was specific stand of the opposite party number 3 in the counter affidavit of the state of Odisha in the counter affidavit that the fisheries extension officer had moved to the proposed site to hand over the layout to the respondent for the excavation work, but he noticed that there was already a small pond with approximate water area of 0.20 acre under another scheme excavated under another scheme, namely Mo Pokhri Yojana. Stop. No decimal. A specific stand was taken that the said Mo Pokhri was completed during 2012-13, against which a sum of rupees 37,716 was released in favor of the job card holders who had worked for the excavation work. Stop. The work. This is how the appellants denied the petitioner's claim for payment of sum of rupees 1,86,000 for two reasons. So firstly, the second pond was not in fact dug, and secondly, the appellant, respondent could not have availed the benefit of second scheme after having availed the first scheme, benefit of first scheme of under Mo Pokhri Yojana. Stop. Learned single judge. Next, learned single judge, after having considered the pleadings on record and submissions advanced on behalf of the parties, has set aside the order whereby the respondent's claim for payment was rejected with a direction to the appellants to pay a sum of rupees 1,86,000 within 2 weeks telling which the amount shall carry interest at the rate of 5% per annum. Stop. Next. Then the said order of one single judge dated 9/5/2023 passed in WPC number 13725 of 2021 is under challenge in the present intra-court appeal. Stop. Next. Learned AGA representing the state of Bihar has submitted that it is manifest from the pleadings on record that the appellant, that the respondent misrepresented the facts in a proceeding under Article 226 of the Constitution of India, in as much as he clearly made a false statement that he had executed the work before 31/3/2012. 31/3/2012, which fact is absolutely incorrect. So he has secondly submitted that in any view of the matter, the petitioner's claim of a sum of rupees 1,86,000 against the work executed, against the work said to have been executed by him, could not be treated as admitted dues. First off, since there was a valid dispute raised on behalf of the state of Bihar in its counter affidavit, the single judge ought not to have entertained such dispute, which could have been decided by a court of competent jurisdiction upon filing of a suit. So, next, then counsel representing the respondent has on the other hand submitted that there was no suppression of any material fact in the pleadings by the writ petitioner, bracketed the respondent. Stop. He submits that there was no bar for a person who had availed. He submits that there was no prohibition he submits that there was no bar for a person to avail the benefit of scheme under MNREGS to be there. After having availed the benefit of scheme called Mo scheme. So stop. He further submits that it is true that the respondent had availed the benefit of Mo scheme, as also the scheme under MNREGS. That is the, which is why during the course of inspection, 2 ponds were found by the fisheries extension officer,
Revenue Inspector Rahama.
Revenue Inspector
Rahama.
Revenue Inspector Rahama on a piece of land owned by the petitioner, respondent. Stop. He submits that whereas the first pond was dug by the respondent for his own use under Mopokhar scheme, the other pond was dug for general public, again on his own land, again on the land belonging to him under MNR EGS so scheme. So stop. After having, next paragraph, after having gone through the pleadings on record, we find a substance in the submission advanced on behalf of the state that the claim raised by the petitioner, a respondent, before the learned single judge in the writ petition would not have been treated to be admitted claim. So stop. The facts asserted in the writ petition were clearly disputed by the state in its counter affidavit in relation to the fact as to whether the second pond was dug or not by the petitioner, by the respondent under MNR EGS. Stop. Such disputed questions of question of fact, comma, in the court's opinion should not be gone into in a proceeding under Article 226 of the Constitution of India, which are decided based on the affidavits of the parties. Stop. Further, no, according to you, the construction was done before 31 3 2012.
15.
15 12 कहीं के है ना? वो 15. But that is incorrect.
Firstly, that it was issued in 2012, madam. The petition was they give 3 months time to complete this work, madam. The
31 3 2012 or 15?
First work order, then
12, madam.
12.
It will be 12.
No, his statement was that he had completed it by March 2012.
Yes.
You had completed that in March 2012. Yeah.
the first work order was completed, the petitioner's stand was that the first, after the issuance of the first work order, it was completed by 31/5/2012, and after the second one, it was completed by 30/5/2015.
Thirty-one five 2012. So stop. The averments made in the writ petition, comma in the the dispute of such nature emerging from the pleadings on rival pleadings of the parties on record could not have been adjudicated upon in a proceeding under Article 226 of the Constitution. Stop. The relief has been granted by the learned single judge, comma, apparently based on the fact, apparently based on the fact that a work order was issued in his favor, which was not cancelled. Stop. These facts, these two facts, comma, in the court's opinion, are not conclusive to determine the right of the respondent to get to receive payment of sum of rupees 1,86,000, which was the value of the work. Stop. Next, accordingly, we are constrained to interfere with the impugn order of the learned single judge, which is set aside, which is hereby set aside. Stop. The writ petition is WPC so and so is allowed, is dismissed. This next paragraph, this appeal is allowed, but without cause. Stop. It is, however, observed. Next paragraph. It is, however, observed that it shall be open for the respondent to approach a civil court of competent jurisdiction to raise his money claim.
Bless.
Limitation, he may say.
The petitioner first approached in the year 2019, my lords. There, this honorable court directed the opposite party, the appellant,
Your
to take a
claim for
decision.
money was 2015.
My lords. Thereafter, the petitioner
So
approached.
after limitation crossed, you have applied. So you have elongated and extended.
Petitioner is a farmer, petitioner is not aware.
So
My lords.
We petition is dismissed. Allowed the paragraph. We cannot lose sight of the fact that the petitioner, that the respondent, for the first time approached this court raising his grievance regarding non-payment of the amount which according to him had become due in 2015, in 4 years thereafter in 2019, by filing the first writ petition, that is WPC number?
WPC. 1 13934 of 2019,
1393
4 of 2019,
4 of 2019.
disposed of on 4/9/2019.
The respondents sued would have been time barred by the date. The suit raising money claim would have been time barred on the date when he approached this court. He had approached this court by filing the writ petition in 2019. Yes.
Only, my lord, two corrections, my lord. One, my lord's dictation, district forest officer, that will be fisheries officer.
Fisheries officer. And
my lord, the state of Odisha.
State of Odisha. That they will correct.
Mayor, please, your lordship. So the petitioner here is challenging the notification issued by UPTCL, the Power Transmission Commission of Odisha Limited. So under 164
this
of
is WA.
WA, my lord.
1742.
Yes, my lord.
Yes.
So here the appellant has challenged the order of the Honorable Single Judge on the ground that the district magistrate has allowed a compensation for two purposes, my lord. One is the towers, the tower-based area which has completely been evicted by virtue of acquisition, and another is line should run over the other lands. So the compensation has also been bifurcated. They have said, the district collector has
Let
said.
us see the order first.
Yes, my lord.
Where is the order?
My lord, may I be permitted to submit? In this case for OPTCL, the contesting respondent, Mr. Ashok Parikar, our learned advocate general, has appeared. He has gone, already left the court. Next Tuesday, maybe.
No, my lord, in the meantime, they are evicting the persons without giving compensation because total villager, if your lordship can see the set of writ application filed, the one of the person have challenged it, and time and again
He has paid certainly. Whether you will be considerate or you
no, we may consider, but in the meantime, no coercive action, my lord. Otherwise, they will be.
No, they will without that goes without saying.
Oh, my lord, I am obliged, my lord.
I'll not say, we will not say anything. Still, we expect that nothing will happen.
Tuesday, is your lordship may fix it to Tuesday or Wednesday.
Wednesday, as jointly requested. List this matter on Wednesday.
Three, my lord. I pray for Tuesday, my lord, if it is possible, my lord.
Wednesday,
for Tuesday only.
As requested.
Item 44. Item 44, Mr. Dholo was doing this case due to personal difficulty. He has gone to his daughter's house. I pray next week any day, Lordship.
There is an interim order, my lord.
Tuesday, Lordship.
As requested. Wednesday.
Great.
45.
Interim order may be continued.
Interim order to one.
45.
My lord, in this case, I am appearing for the petition.
Item 45. I am appearing for the OP number 5 for the first time. I request
You are appearing for the OP number 5 for the first time.
first time.
My lord,
Last time,
on last occasion.
1 week's time, I will find out reply. Just 1 week time.
I am appearing for the OP number 8, my lords. Pollution both. I have been served upon the rejoinder copy.
Copy in rejoinder, on last occasion, your lordship directed to file rejoinder. I have filed the rejoinder.
But he wants to file counter affidavit.
My lord?
He wants to file a counter affidavit.
Counter affidavit. But
So let him
without
file.
paying any compensation, they have acquired the land. For that, my lord, on last occasion, your lordship, I have also in rejoinder, the government has stated that they have paid all the RR benefit and compensation, but actually they have not paid. And kindly have a glance to the letter.
No, but let him file counter affidavit first. Let the pleading
Short
be
date may be
completed.
fixed, my lord.
Hmm?
Short date.
Short date, 4 weeks.
My lord.
4 weeks, 4 weeks.
My lord,
List this matter on 4 weeks. in view of submission made on behalf of
OP number 5.
OP number 5, that he requires time to file counter affidavit. The top, let the counter affidavit be filed within 3 weeks from today, after serving copies thereof on learned counsel for the parties, so as to enable learned counsel for the petitioner to file a rejoinder if so required. So 3 weeks, and you will have 1 week time to file the rejoinder. No further time.
My learned friend was supposed to take instruction.
And last occasion, the Lordship has directed me to take instruction. That is my Lord's order dated 31/1/2024, 3/1/2024. I've got the instruction that he cannot be granted. This is the instruction.
This is regarding what?
Temporary recognition of knowledge. So I was praying for some time to go through it. If your lordship calls it on the next date, Wednesday, I will argue this matter finally. Let your lordship decide it. I will also have some time to go through the
Wednesday?
Yes, ma'am. I've given that instruction. In compliance to my Lord's direction on 3/1/2024.
As requested on behalf of the petitioner, this matter on Wednesday.
Grateful.
This 13/1/2020 letter is there on record.
No.
3/1.
No, this letter is not there.
13/1.
31/1.
13/1/2020.
Yes.
That is there.
Yes.
23.
47.
It's better me pursuant to Lordship's judgment direction, Lords, ₹24 lakhs and order has already been sanctioned in favor of the petitioner, Lords. And he was called upon to file the documents and bank account so that the amount can be transferred. On the document, it is found that his name in the Aadhaar card is Panchu Das, but bank account is something else, Lord. So he has been requested by the letter dated 20th to give the details of the bank account so that amount can be disbursed, Lord. So we have complied with Lordship's order.
We will wait till the amount is deposited in his account.
But Lordship because he is not, till date, he has not given the bank account. So Lordship may clarify that on the petition of giving the bank account, immediately it shall be transferred.
There is no representation on behalf of the petitioner. Learned AGA representing the contemners submits that this court's order, violation of which has been alleged in the present contempt application, has been substantially complied with. He, however, submits that because of the failure on the part of the petitioner to furnish Aadhaar card, bank details.
No, he has submitted those things, but the names differ in both.
That
Discrepancy in the names.
Because of the discrepancies in the documents furnished by the petitioner for the purpose of the amount,
Disbursement of.
for the purpose of disbursement of the amount in proper bank account, the amount has not been deposited. So stop. Next. He further submits that the petitioner has been asked to overcome the discrepancies. So to accomplish this matter on 2 weeks for 2 weeks. First of all, the court makes it clear that if the petitioner fails to rectify the defects and or / remove the discrepancies, the court will consider dropping the contempt proceeding on the next day. 48.
My lord, I have already appeared for the respondent 1 and 2. I will file the counter to that the amount they have managed to withdraw from the corporation. Some time maybe.
48.
My lord.
You are for the respondent.
1 and 2. The widow and the minors.
Widow and the minor. 1 and 2, I have 3 and 3, 4 and 5. In compliance of the lordship's order of the last day, order admitting the appeal, they have totally taken care of the amount due. The amount due is only gratuity on the agency hold and renewal premium.
Yes, we remember you had taken a very fair stand.
Yes.
So the amount has, where is the question of filing counter affidavit?
My lord, the appellant has managed to withdraw 12 lakhs without the knowledge of the respondent widow and her minor son, my lord. Not a single pie has been received by the respondent, whereas the appellant has managed to withdraw the 12 lakhs, being the nominee. I'll file that document. A civil suit as the learned court below has ordered in the civil suit to.
You are the appellant.
No, my lord, I am the respondent.
Who is the appellant? You are the appellant.
My lord, I am there.
Interse dispute. Interse dispute.
Interse, my lord, I am the widow of the deceased, who is the son of the appellant, my lord. And the respondent 2 is the minor son.
Who is he?
He is my father-in-law.
Then it is interse.
How can we decide? Who is the nominee?
I am the nominee. Appellant is the nominee.
Appellant is the nominee.
My lord.
And who is entitled under the law?
As per the law, the nominee is entitled for that. So last time your lordship has. My other page.
Insurance Act.
Highlight.
Yes, money will have to be paid to the nominee under the law.
Well,
because if your lordship will permit me to assist your lordship in this case, there is a division bench judgment of this court wherein similar dispute arose, my lords. The widow, here the other thing, widow was the nominee. She withdrew the entire amount, did not pay a single pie to the mother, my lords, of the deceased, her mother-in-law. Writ application was filed. There this court, my lord, decided the nominee is only, my lords, to receive the amount.
Oh, no, not in insurance.
No, there is a judgment. That's what I'm saying, my lord.
We will see.
And he or she will, my lord, share with them, my lord.
Oh, no.
Because otherwise the nominee will take back the entire amount.
Yes.
That is the.
That is the will of the.
No, I don't say. Because there is a contrary judgment, I want to show to us.
That is the will of the person in short.
And categorically, my lord.
Nominee,
because in some
nominee
cases,
in a bank account is different from nominee in an insurance policy. It appears from the language of the. There must be decisions on this. So many decisions.
My lord.
We will see. We will decide it.
And prior to 2015, it was something different. And once this has been amended, it's clear that they have got clear wordings. And they say what is the role of a nominee. Clear. There is no ambiguity in this. And if it is the nominee, if the parent is the nominee, he is the person to get that amount. And if after the death of the
not only that, if we read this provision, then if a stranger is a nominee,
exactly.
Whatever it is,
the stranger will be entitled.
Exactly.
No other person.
No other person is entitled.
Now, Mr. Substitute, what you say is a compassion to distribute the money amongst themselves after disbursement.
After disbursement.
Suppose there is a, say, bank account.
It is
Any
not
number
that
of
way.
nominees.
In this section, what they say, nominee or nominees.
Nominee or nominee.
Nominee or nominees. And specially they're saying if parents or spouse, then it is specifically no other person can claim it. And in this case, I am the father. I am the father of the deceased. And I have been made nominee. And as far as this entitlement of this, what is that?
No, but who is she?
She is the widow.
She is the widow of my son.
But why is she fighting with you? And why should you fight with her?
I'm not fighting. I'm not fighting. Last time, Your Lordship, I told, I have got no objection if it is shared. But my question is, right now, my question is, the learned single judge has passed an order which goes against this law. What I mean to say is, this will become a tradition.
Please take some stand.
But my lord.
On the next day, please take law is one thing.
I accept it, my lord.
Okay. And then your family is another.
My lord.
So we will be declaring law, we will be deciding law as per we are not sure. Whatever view we have taken is tentative, is prima facie. We may change our view based on any decision or interpretation which is given either by you or him. That is our tentative view.
I don't dispute, my lord.
You are not disputing, right?
I'm not disputing.
So therefore, when you address the court on the next date, please come with judgments. There must be judgments on this point.
Yes.
So please come with the judgments, assess the court, and we shall be declaring law on the basis of that provision. At the same time, you should also take fair stand. If you are taking a fair stand, it's not that you have not taken a fair stand, but some sympathetic stand also you may take. You may not. The court shall not compel you to do something which law does not permit. But your conscience may permit.
No, I'm to that, my lord. I'm strictly to that. The thing is that I am a person of 86 years old. I'm an elite person. I'm a very sick person. Apart from that, the other son is a mentally retarded, 80% mentally retarded. Suppose I die someday, I don't have a single part to survive.
We will see that.
I don't say that at that stage also. I don't say I doesn't disagree that she should not get anything. But the principle should be settled. That is my point.
We'll see on the next day, on Wednesday. But please come with the decisions.
1984 Supreme Court, my lord, 346.
84. When
15. Amendment is on 15. That's why after 15.
So you will have to come with the judgments post 15. Please do some homework.
Well, all the policies were taken before 2009 and agency was before that. The deceased life assured. So the law prevailing as on the year
These are the legal issues which are required to be addressed.
Daughter-in-law and mother-in-law.
Absolutely. We are ready to hear you, but please come with the decisions on each and every aspect. He is saying 15. You also appear to be correct in your submission. 2015 amendment may not apply because so all these things are to be decided. So that decision which you are referring to
I
must be
will
of
also, I will
prior
also
to
assist you also.
2015.
No, prior to 2015, because
Prior to 2015.
Exactly.
Still you may be correct because this policy is of 2008.
there it has been held that father is not the class 1 legal heir, only mother is the class 1 legal heir. So mother was given a share. That I will come up with Justice Honorable Justice R.K. Patra's judgment. I will come up with.
My lord, in this amendment, there categorically says where the role of this legal
No,
heir
but
comes.
he has a valid point.
Yeah,
Whether
I do admit. I do that I'm going to face it. But what the legal heir, the role of legal heir is specifically mentioned. Suppose the nominee.
we will
dies.
see that Wednesday.
Obliged, ma'am.
But prima facie also, whether 2015 Amendment Act will apply to this case or not, that is also a valid point to be seen.
He has come up in appeal against the order of the order single judge, excluding the nominee and giving the entire remaining benefits to the woman, wife or the grandson. Therefore, he has come up. We have to apportion everything, we kept it in reserve, we will grant as per your lordship's order.
In this case, I have instruction to appear on behalf of the Bhubaneswar Municipal Corporation, but the named it's the contempt case, and the two names, two opposite parties are there who are no more working in the BMC because they have already been transferred. And in the meantime, it did not be amended also. The petition has not been amended. And I have also instruction the
See, the petitioner is not required to amend. It is the duty of the court to ensure that the person who violates the order is punished.
My lord.
All right. So you please don't raise that.
To that, I will file an affidavit.
You file an affidavit. You will have to tell the court that the order has been complied with.
My lord.
And if you say otherwise, then
my
you will
lord,
initiate action as requested on behalf of the Bhubaneswar Municipal Corporation. Huh?
3 weeks after.
This
Now
matter
the election is going
on 3 weeks for him to seek instructions and inform this court as to whether this court's order has been complied with or not. Hey.
No, but my instruction is that the direction was to comply in accordance with law. And my instruction is it has been complied with.
All right.
But to that, I have to file an affidavit also.
File.
Item
Next is, sir.
3 weeks.
Item
49 and
50.
50 both.
49 and 50.
Item 50, my lord, second round contempt.
Second round.
Yes.
We cannot enhance the punishment on that ground. Punishment will be either 1 week jail or something.